Yes, sir.
Thank you, Adarsh. A very good morning to all of you. We are here to exchange ideas and collaborate in the seminar, which talk about claims and disputes, arbitration in construction and infrastructure sector, Indian and international perspective. On behalf of CII and on my personal behalf, I welcome you all and I am delighted to say that we have an excellent amalgamation of speakers today. I am taking this opportunity to welcome Honorable Justice Deepak Misra, former Chief Justice of India, Honorable Justice A.K. Sikri, former Judge Supreme Court of India, and Mr. Amarjit Singh Chando, former ASG of India. The spread of COVID-19, also known as coronavirus, which was declared a global pandemic by the World Health Organization on 11th March 2020, has had a significant, in some cases disastrous, impact on virtually all areas of business globally. The construction industry is no exception. With a number of countries declaring a state of emergency to fight the pandemic, closing their borders and imposing travel restrictions, on-site construction activities have naturally been affected. From shortage of materials due to interruptions of project supply chains, shortage of workforce and labor, prohibitions on gathering on groups of people, in some cases of more than 2 people. In certain countries, the complete suspension has derived in all construction activities. The restrictions imposed have had a significant impact on all parties involved in construction projects, not to mention severe financial consequences. The remedies available at law to the parties to a construction contract to protect their rights and mitigate their losses in these highly unusual circumstances depend on the terms of respective contract, but also on the governing law in question. COVID construction disputes claims time and money. Hence, fast tracking of disputes is very essential for ensuring ease of business for the sector. In this webinar, the construction law specialists, experts, industry veterans across globe will take stock of the situation and look forward to 2021. Will the commendable intentions of working collaboratively in these trying times survive the turn of the year, or will the new normal quickly return to the old normal with claims escalating all too rapidly into full-fledged disputes? The webinar will deal with common cause of claims, COVID-19 related and others, and we'll take a closer look at how such claims are governed under the major international construction contracts. The different possibilities to avoid claims from evolving into disputes will also be explored with a focus on current specific challenges. Dispute resolution evidently remains a major topic, as not all disputes can be avoided. Proceedings are becoming increasingly virtual, which has its pros and cons. The speakers will not only discuss new evolutions in litigation and arbitration, but will also elaborate on recent trends. This webinar will cover what the newest trends are in construction claims and disputes, as well as will offer advice to industry professionals about how they can minimize problems resulting from these trends. Today, the focus discussions will cover limitation on recovery of damages, compensation, expert legal perspectives, disruption and loss of productivity claims, damages, whether it is compensable or variation, and how it can be mitigated, notice and filing requirements, forensic delay analysis, COVID-related constructive claims, the inapplicability of liquidated damage for delays and the relevant factors, unlawful termination and the encashment of bank guarantees and its legal perspective, challenges and enforcements of arbitration award, hot topic in arbitration, interim relief, emergency arbitration, third-party funding in arbitration. I'm sure today's deliberations will help facilitate many solutions for this sector. I wish a great day ahead. Thank you. I would like to request Mr. Amarjit Singh Chando, former ASG India, to introduce to our guest of honors.
Honorable my Lord Justice Deepak Misra, my Lord Justice Arjun Sikri, Mr. Subhash Sethi, Mr. Adarsh, all participants. There could not have been a better honor to me than this to be given this responsibility to introduce two eminent honorable judges and jurists of this country, whose contribution to the cause of justice, and if I can say so in reference to the claims and disputes and arbitration in construction and infrastructure sector, is well known. Volumes across the judgments would speak their acumen, their wisdom, and above all, their intervention for resolution with respect to the various claims and disputes and conflicts in this society. My Lord Justice Sikri, one had the pleasure to rub my shoulders with his Lordship when his Lordship was a lawyer practicing in Delhi, in the Supreme Court and the various high courts, and primarily in Delhi High Court. One saw the great day coming to us when his Lordship got elevated to Delhi High Court. And over the period of time, one had the privilege to work with his Lordship, heading the Bar Association of the High Court on many occasions, and saw how we can resolve disputes which otherwise hit and would have taken serious trends even between bar and the bench. I don't need to say much because it's very well known, his profile is before you. But I want to bring to your notice something total human about his Lordship. And that is that even in a conflict where a child was deprived of an education in MBBS, his Lordship sitting on the bench had put a question to me to say, how do we resolve it? Though he had made a wrong declaration. My lords agreed to that suggestion made at the bar, incorporated that in judgment, and said this child, for only making that wrong declaration, would not be deprived of his education. And he was allowed to continue his MBBS course, but was requested that his internship would be in Tihar jail serving the intimates. And after that, when we moved an application, I wanted to bring to all participants in all August gathering today, that child went for 1 year internship in jail, and when his application was filed by us to say he should be allowed to go for post-graduation, the jail intimates through the superintendent jail moved an application to say, can he be allowed a special privilege to remain in jail? We love this doctor. We love his way of dealing with the situation. And I'm proud to tell you, today that doctor is healing the wounds of many, may not in this motherland, but in the United States of America. And one of the doctors who is looked after for his acumen in his medicine. And that is the result of none else but his Lordship's contribution to the cause of justice. If this is the meaning of the word justice and access to justice within our constitutional norms, then I think we need to look at this aspect of the picture while we are resolving disputes in the construction industry. I think more of them can be resolved than be adjudicated upon by adversarial means. My lords will throw light on that part. I've just given a hint. May I request your lordships, my Lord Justice Sikri, for his lordship's special address.
Thank you, Sir Amarjit Singh Chandiok, for your kind and gracious words. My Lord Chief Justice, Justice Deepak Mishra, he remains my Chief Justice because he was my Chief Justice in Delhi High Court, he was my Chief Justice in Supreme Court, and I was with him in Collegium in Delhi High Court as well as Supreme Court as well. So I had the pleasure of working with him very closely. Mr. Sethi, Mr. Adarsh Kumar, Ms. Atika Vadhavan, and other distinguished guests who are attending this very, very important webinar today. As Mr. Sethi has already mentioned about the importance of this topic insofar as disputes or resolution of disputes are concerned in the construction industry, more particularly because of COVID situations. because COVID has no doubt hit the entire economic activity. It has, in so many ways, affected the lives of the people. It has taken away the lives of many people as well. But when we come to the economic scenario, and of course, as we know that GDP has been reduced, our growth projection is much, much low. Last year also that was the situation. And in the whole process, the construction industry or the disputes relating to construction industry, they become very, very relevant. Number one, we know that infrastructure or construction is the backbone of any economy. So therefore, there has to be the continued growth in infrastructure projects as well as in construction. You know, after the globalization and liberalization of Indian economy from 1991 onward, in last 30 years, India has made big strides, and the GDP has increased substantially, phenomenally. The middle sector, this middle income group has also come up. All these has led to increase in the infrastructure and construction activity. At the same time, we also know that whenever such things take place, or projects are undertaken, or construction projects or infrastructure projects are undertaken, the disputes are bound to arise. There may be so many causes of such disputes, even when the parties do not desire it to be so. Number one, that parties may take certain positions that no, both the sides, whether it is the contractor or it is the employer, they take their position, which we normally address in mediation more, I mean, effectively when such positions are taken. That and both of them think that they are right. Then because this is the human nature, you can't avoid it. And then there are many situations which arise because of which disputes are bound to occur. It may be clauses in the contract which are not very clear, and interpretation which is to be given to those clauses, or inadequacies in the contract. But apart from that, what we have to see is the primary cause for such disputes, in particularly in infrastructure and construction matters, and which I have seen in last two and little over 2 years as arbitrator now, and earlier saw it as a judge of the court, that invariably these infrastructure and construction projects are not completed in time. Many times they are not completed at all, and it leads to termination. But even if it is completed, maybe more than 90% cases, it is not within time. Even when the contract says that the time is the essence of the contract, the delays may be because of various reasons, and it may be faulty or incomplete planning and preparation. It may be delay in handing over the site, and due to encroachment or other hindrances, etc. It may be lack of funds. It may be delay in giving payments to the contractor. It may be that the drawings for the construction are not ready, and sometimes delays are due to late approvals, taking of late decisions by the employer, lack of communication between the parties, and variation in the drawing specification and quantities, etc. when the work is in progress. And another cause for delay may be which are unforeseen circumstances like force majeure, natural disaster, and public interruption, and that COVID comes under this category. Now, when the such disputes and arise, and the issues which normally are that first is extension of time, but then the contractor wants extension of time with the revision in the rates and price escalation because delay has taken place. Then normally we have seen the kinds of disputes which or the claims which are preferred are about the idling of resources, overhead expenses, loss of profits, etc. Now these kinds of issues are raised. But interestingly, it may be easy in such cases when the in any normal case, when such disputes are raised and the delay is whether it is on the part of the contractor or it is on the part of the employer, because both blame each other. But that may not be very difficult task for any arbitrator when the evidence is led and before the arbitral tribunal to decide on whose part the delay is. But some of the legal issues which arise is because of certain clauses in the contract itself. Number one, exclusionary clauses in the contract, which normally provide that even if there is a delay on the part of the employer, contractor will be given only suitable extension of time and no damages or no money will be paid on account of this delay. There are certain clauses many times there. And then there are clauses regarding capping of the damages that even if the compensation is to be given, it will not be more than 3%, 4%, 5%, etc. Such clauses are there, but the contractor feels that no, they are very inadequate to compensate. Then I've seen certain clauses that no interest would be payable, even if the some claim, etc., or late payment is there, but no interest would be payable. That specific clauses would be there. And then there are accepted matters in certain clauses that such kind of cases will not be taken up in the arbitration proceeding. And of course, the issue of mitigation of damages in all such circumstances which arise. What I feel is, of course, all these are going to be discussed in this webinar. And as Mr. Sethi has already flagged those topics which are going to arise. And but two things which I would say here in respect of exclusionary clauses and where the law is still, even after 20 or 30 years, in a fluid situation, and how the courts or the arbitral tribunal has grappled with such issues, or the delay. What happens, I have seen in most of these cases, and particularly the domestic arbitration in India, even when the delay takes place, it is possible that in certain situations, some delay is on the part of the employer and some delay is on the part of the contract. But there is no proper delay analysis. Only the contractor would say delay on the part of the employer because of XYZ reason and vice versa. Suppose delay is of 300 days or 400 days, out of which how much can be attributed to the employer, how much can be attributed to the contractor, and how much is the concurrent delay. There may be concurrent delay. There may be inconsequential delays which have not affected the project otherwise. All these become very, very important in putting the burden on the contractor or the employer. So this delay analysis is very important in the construction arbitration, and so this Society of Construction Law has come out with the delay and this description protocol. I think that should be followed by the lawyers, and should, on that basis, the evidence should be produced before the arbitral tribunal. Coming to another thing which I told was about these exclusionary clauses and capping up of damages, etc. Now here, the normally it is because this is again one of the most contentious issues I have seen in. I must have given at least 7, 8 awards in last 1 year on construction aspects. But this is the element which is argued in every case by the employer, that look, because of these clauses, no damages or no compensation is payable. They specifically preclude. Now, there are some judgments on which are relied upon by the employers, saying that, look, the arbitral tribunals are bound to follow the law, and therefore follow the provisions of the contract, and therefore they are not permitted to grant any damages. On the other hand, the contractors always say that, look, contract act section 73, 74, etc., when they give us the right to claim damages when there is a fault, we have not come and we have not undertaken this project to suffer the losses, so we are supposed to be compensated. And there are judgments on both sides. How to read those judgments, how to reconcile those judgments is the challenge before the arbitral tribunal while giving these awards. What I would say here, as I have analyzed some of these judgments, you people are going to discuss in detail, but and therefore I'm not referring to most of these judgments, but some of the principles which are to be kept in mind while analyzing the exclusionary clauses are that this when the delay occurs, that too on account of default attributable to the employer, and because of this reason the execution of the project is prolonged, it entails extra expenditure, it cannot be denied. So that is one thing which has to be kept in mind. And under such circumstances, Section 73 of the Contract Act gives right to the contractor to claim the damages. We can apply here business efficacy test also. I'm not stating in detail about that because of paucity of time, and but it has been stated so by the Supreme Court in so many cases. And other thing which is that some of the cases which can provide us the guidance is that where the Supreme Court has also held that such clauses of exclusionary clauses are to be strictly construed, and only in exceptional circumstances when it is very clear that it can be denied. What I have seen from various judgments, and there are the courts have found some ways to salvage the situation. Number one, if I may say so in brief, when the contract is not completed within the stipulated time and the fault is attributed to the contractor can refuse to perform the work beyond the initial period of the contract and say that unless I am paid the extra or the rates are revised or extra payment is given. That is also reflected in, if you see, section 53 to 55 of the Contract Act. The other, and it has been upheld by the court. The other very important aspect which can be seen, and it was stated in Bharat Drilling and Foundation Treatment case in 2009 by the Supreme Court, that such clause puts a bar on the department but cannot be treated as restraint on the arbitrator. So when the claim is preferred by the contractor before the department may say, sorry, we are bound. But then the arbitrator is not bound because arbitrator is supposed to go as per law. And the law permits under the Contract Act to grant such damages. And in some cases, the courts have held that exclusionary clauses is not applicable on the extended period, but only when the delay occurs within the period specified in the contract. So when it goes beyond that, exclusionary clause stops to operate. And another very, bold judgment which was given by Delhi High Court after noticing the conflict of decision, some of the decisions of the Supreme Court on both sides, they said that look, such a clause is contrary to Section 23 of the Contract Act, and therefore these clauses are void. We may not go to this issue is pending in the Supreme Court, and therefore we may not go into that issue. But then these are some of the aspects on which the clauses can be interpreted. And of course, as I said in the process, whether capping the damages or mitigation of damages, etc., these issues do arise, and on which there would be detailed discussion. But as was rightly pointed out by Mr. Sethi in his introductory remarks, the COVID situation has again brought about so many issues which are bound to arise, particularly force majeure issues, etc. Now, when you take exclusionary clauses on the one hand, which is interpreted to mean that no, in spite of that, the courts can grant the damages. What happens when the project is delayed and the work could not be carried on because of COVID conditions? So, and if it amounts to force majeure, whether even in spite of that, whether the contractor would be entitled to, but I have seen in certain public sector undertakings, they have extended the time, they have revised the rate, but in many cases, this has not happened. And the contractors are not willing. So, but then the clauses are there that you cannot claim the damages. So, whether such clauses can be invoked by the employer, giving the justification that it was not delay on our account, but it was because of force majeure conditions. These are some of the aspects which are going to, be ticklish, and which will come before the courts or come before the arbitral tribunals. And I hope that there would be a better discussion on this by the panelists. I need not go into various other issues, but only one comment I would make at the end, that when this is one of the inherent feature and philosophy behind the construction and infrastructure contracts, that even when the arbitration takes place or disputes arise, the project should go on, because these should not be affected because they are of prime public importance. That is why it is also the ethos that when the disputes arise, they should be settled as early as possible. And because of COVID condition, what I feel, apart from arbitration, that the time has come to use mediation. And mediation is one sphere where both the parties sit when they see in COVID conditions that it may not be that either the contractor was entirely responsible or the employer was entirely responsible. Such issues which when they arise, they are better suited for mediation than the adjudication. So with this, I compliment CII for organizing this kind of webinar on 2 days, today and next Saturday. And I hope that there are going to be very valuable discussions and the churning would produce much material for us to think about, and many solutions will emerge in respect of very tricky situations which may arise due to COVID. Thank you very much.
Thank you, my lord. Thank you for your special address, for giving us all the aspects with respect to the exclusionary clauses in the contract, with respect to what we should do, how we have interpreted the same. And at the end, your lordship gave the real need for the hour that we must use mediation, especially after India has signed the Singapore Convention, and now that the Singapore Convention is in operation, international disputes by mediation, by the agreement itself, would become enforceable. Thank you so much, sir, for giving all these aspects and in broadly. I must say that though 125 years history of CII gives it a large ambit of how to deal with it, but I think time has come when CII and Pro Ultimus both will sit down to see how we have to draft the agreements also. I think there's a time for us to see that we stop using templates. We look at the law laid down by the court, changes in law that has brought in, and then start writing our agreements. Because most disputes can be resolved if your contract is clear and absolutely the intent of the parties is made out. This gives me the opportunity to bring in none else but the former Chief Justice of India, Honorable Mr. Justice Deepak Mishra. His journey as an honorable judge started in 1996. From Orissa, went to Madhya Pradesh, came back to Patna, and then became the Chief Justice of Delhi High Court, where one had the occasion to be a part of his blessings because of the President of the Bar, and had a time to, I think the time that we have enjoyed together is worth for my memory. When his lordship got elevated on 28th of August 2017 as the Chief Justice of India. And many of us who probably do know Justice Mishra personally can tell you he is a person who knows various languages, a person whose hospitality one would enjoy at any time, and the person who taught me, first of all, don't take tea or coffee without a biscuit. Therefore, it is not good for your stomach. Therefore, look at the ambit of his acumen, from health to Sanskrit shloks, what we saw in the law and what we see it. And I remember his lordship's judgment in a service tax matter where almost all stalwarts on the other side were opposing. And he put a question to me, do you think you could be able to defend the action of the government? And I said, yes, my lord. And in para 43 and 44 of his judgment, your lordship then notes that the very fact that a person is giving a commercial property, which is reference to infrastructure and construction for you people, service tax becomes important because the position of that property itself renders a service by the landlord. Now, these are far, I think, volumes of courts right from Madhya Pradesh or Odisha to Supreme Court will show my lords the way he has unfolded the references that were made to the Supreme Court. And best of all, I think for me, it looks the Honorable Judge, how he dealt with people in his chamber and outside the court was equally important. May I request the Honorable Chief Justice of India, my Lord Justice Deepak Mishra, to please have the inaugural address.
Justice Secretary, a dear friend and colleague, Mr. Chandiok, former President of the Delhi High Court Bar Association and the Additional Solicitor General of India, Mr. Sethi, Mr. Adarsh Kumar, and ladies and gentlemen. In 1920, sometime in the middle of last century, a psychologist wrote a book on economics, and he was awarded Nobel Prize. I had the privilege of reading the book. Despite my limited understanding, I enjoyed the book. The book speaks of instinctual analysis and analytical analysis, or to put it differently, instinctual statistics and analytical statistics. As far as today is concerned, I'm really not interested in dwelling upon instinctual statistics. I will delve into the concept of analytical statistics. I have been able to gather that the construction and the infrastructure sector has been able to garner quite a huge amount of FDI in 2019, 2020 also. This year there has been some decrease, but not materially affecting. It's also interesting to note that employers of this sector is the second largest in India, and their investment gives rise to health in economy as well as a habitat for the people who are in need of it. It's one of the 10 largest sectors attracting highest FDI. It requires distinct expertise and in-depth wisdom. I'm using the word wisdom in the sense, as Justice Sikri has pointed out, when two sets of judgments are cited before you as an arbitrator, you are not sitting in court, let me remind you, then you have to really churn through your experience, call in your experience as a judge, how to understand, how to distinguish, and how to apply it so that your neutrality as an analyzer cannot be questioned. That is the arbitrator's job. It is very easy to say, I'm a creature of the contract. It's not that way. There is some leeway the judgments grant, and one has to understand it and not get confused. Having said that, the issue really that remains for consideration, how to build up an environment for creation of world-class infrastructure in India. Mr. Chandiok has said Jack has 125 years of experience. We claim to be that old, but indubitably, we have the potentiality to build. I have thought of 6 possibilities which are taken together, we can have an epitomized, properly structured environment. Firstly, there has to be a robust legislative and policy framework. Second, appropriately developed public institution. Thirdly, a strong project governance structure. Fourthly, strengthening procurement process and improving contract management. Fifthly, astutely pyramiding people management processing in order to develop the project management capabilities. And sixthly, provide for an affirmative and strong mechanism for resolution of disputes that may arise. Today's webinar is really concerned with the last facet. As Justice Sikri pointed out, and I entirely concur, there has to be a proper formation of contract. Prior to that, the processing of tender, transparency in bid documents, using of understandable language are also absolutely significant. When we are thinking of contracts which has transboundary envisagement, clarity has to take the first place. What happens ordinarily? They refer to bunch of papers, general conditions of contract, or the bid terms. The contractor, in his anxiety to get the work, signs those documents, least understanding what will be the impact. I am not saying they are not taking legal advice, but first and foremost concern is to get the work. Here lies the morality of justice. As Mr. Chandyok pointed out about the admission of that medical student in a different context, there is a distinction between law and justice. We are talking about law because this is strictly a commercial law. But an owner who floats the tender must also appreciate that it's a project. It's a national asset. It has to be completed. So I must be fair and just in drafting and the forming the contract with the contractor. That's the best mark. With the increase of this economic activity and global constructions disputes coming at large, India has to reciprocate. India has to stand up. We do not have to take an attitude which will introduce unnecessary opposite position. We must proceed and move with the philosophy of commerce in the world scenario. And for the said purpose, there is a requisite of rational involvement of all the stakeholders. First stakeholder is the legislature. There is a principle whenever there is a societal cry, it's not the societal cry from the people who are suffering, even people who are working or people who are building projects. There is a need. Then the legislator responds, and that is what called responsive legislation. 1996 has been amended and it has been given a healthy shape. I must say that. But still, certain amendments are required. I would suggest for the present at least two. One, emergency introduction of passing of emergency hour. I'm conscious there is section 17. I'm also conscious a judgment had been delivered yesterday in Amazon case that there is no express or implied prohibition. But the context was different. One has to really deliberate on that. But once a statutory provision is there, it's absolutely clear to everyone. The Law Commission had so recommended in its 246th report. I am of the considered view the same should be given a statutory provision. Second, with regard to the exclusionary facet which Justice Sikri highlighted, that was frowned upon by the Supreme Court in 2009. So, in the statute, and I don't think it is an alien concept or alien perspective to legislation to set up a guideline while forming these contracts relating to infrastructure and construction. Third, that's a part of second one. During the execution process, I have to say this, the specific role of the court must be defined. A transitory provision was introduced under section 36 that was amended. I mean, one has to really give it a shape. The language and the expression must be absolutely clear. Now, having said that, now I will focus on seat of arbitration. The Supreme Court has clarified the position, and it's a progressive judgment, I must say, that two Indian parties can choose a third place, a country other than India as the seat of arbitration. But prior to that, I have always maintained you must assess the cost factor, the judicial approach, the approach to damages in India and approach to damages outside are different. That assessment has to be done by the legal experts like you people, and you must advise the parties seeking your help. We are not in a lesser position, but we don't deny there are centers which are more experienced outside, but we must understand our financial element. I am using the word element deliberately. Now, something struck me the other day. While the hours are tested or Section 9 application is filed, I know the courts having original jurisdiction, the Commercial Courts Act 2015, they have been conferred the power of commercial courts, but there can be special courts to specifically deal with these aspects. But because this requires experience and as well as expertise, this the judges know, I do not deny, but there can be discussions, deliberations, and question answer sessions in the National Judicial Academy. The High Court judges go there, and that is not training for them. Training is for the subordinate judges in the State Judicial Academy and their vision improvement in NJA. But when the High Court judges go, there is a participation. The experts, technical experts, techno-legal experts can come and discuss with them. There had been some attempt in the past, and there has to be continuity of the same. Now, I have seen in certain cases, the arbitrators need the experts. The parties cite the expert witnesses, be it a civil engineer, electrical engineer, or a technological personality. That witness has to be appropriately examined. There has to be a skill to examine and also evaluate his testimony. Simultaneously, I would also like to add the said witness being an expert and experienced in his field, he must depose with objectivity. He must understand as an officer of the court, he is not an officer of the court, but I am saying, I am giving him the status of as an officer of the court, must assist the arbitral tribunal. With the passage of time, the landscape of arbitration is changing. The concept of delay and damages are taking a different scenario. I'm not getting into the type of damages claimed and the pleas of avoidance by the employer or owner. But there has to be a balance. At this juncture, I am tempted to say in a dispute or in a person, there can be on equilibrium and balance. On equilibrium and balance. The role of an arbitrator and the arguing counsel is to bring in a perfect balance between that unequilibrium and the existing balance. He has to accentuate it. That balanced condition will enhance the pyramidion of this infrastructure and construction field of arbitration, mediation, and dispute adjudicatory resolution. That I'll fail in my duty if I don't say I'm extremely delighted to participate in this webinar, and I congratulate the organizers to have such a webinar, having such great intellectuals to participate, to share their thoughts, and also enhance the balance of arbitral proceedings and the interpretation of arbitration clauses, and further to help the economic growth of India and assist making India a hub of arbitration. Thank you. Thank you, everyone.
Thank you, my Lord Justice Deepak Mishra, the Honorable Chief Justice of India, for that voluminous address to all inaugural address. The sixth principle that your Lordship has underlined, I'm sure the industry, the professionals, everybody will take a look at it. And those from the government, if they're hearing us, they'll probably be able to look at it to see how amendments can be brought into the picture. My Lord made a very relevant position with respect to the element in India, and that element in India, as I can give you an example, with respect to, for example, in intellectual property. In India, we have from Delhi itself about 67% of the cases decided all over the country. And out of those 67, to be more appropriate, 52% are decided on injunction, not on damages. Therefore, damages is hardly a consequential in an intellectual property matter. Therefore, when you are agreeing to go to a foreign jurisdiction, no dispute. The Supreme Court says we can go it, but we must look at, as Lordship has rightly suggested and advised, that what is the element with respect to damages where we have to be assessed in the foreign country. And I, with all sense of humility and pride, must tell this august gathering, I think the element that we have in this country of the professionals in arbitration, of these professionals who can look at the infrastructure industry, of the professionals who can look at the construction industry, you will not find anywhere else in the world. And I must, with all sense of pride, again say, there is no law firm in the world today which does not have an Indian lawyer or an Indian consultant to be part of it. So be more favorable to your own country. Make all stakeholders, and I request CCI as well as the Pro Ultimus, which has a lot of industries to cater to in the Middle East, and look at the bank, Exim Bank for India. It only provides association, provides funds in the subsidiaries that we have, over the Middle East. So we need to bring all those arbitrations into the country. And I'm sure a day will not be far when India shall be the arbitration hub. Let us all pledge that in these pandemic times, we collaborate, we collate, we talk to each other, have better communication, have the advice of our honorable judges who have given us points today to take this industry forward so that we can bring respite and solace to that human being who has either suffered individually or collectively or through his family, and bring the economy of the country back and bring back and make this country as the world economic leader. Thank you very much. Thank you, CCI. Thank you, Pro Ultimus, for arranging this webinar. As the Lordship rightly said, the intellectuals, the experts from various fields, both national and international, will dwell upon those 2 days and will probably iron out many things that we are looking at, which probably we need clarification on. Thank you very much. Thank you, Mr. Sethi, for leading us in this great endeavor. We are sure the 2-day deliberation will bring the requisite result. Thank you very much.
Thank you, Justice Sikri. Thank you, Justice Misra, and thank you, Mr. Chandyok, Mr. Sethi, and all. I would just request Mr. Sethi to just closing remarks, and then we can start the technical sessions.
I would like to thank our guest of honor for their great input. Honorable Justice A.K. Sikri touched upon many aspects of contractual issues which comes while adjudicating a arbitration. And he very rightly said that the arbitration has become very matured. In fact, we found that a lot of delay analysis is not being given when there is a delay in the contract or when there is a dispute between the employer and the employee and the contractor. So his few inputs that how to prepare the claim so that the arbitrator can decide appropriately. Thank you, Justice A.K. Sikri. Honorable Justice Deepak Misra spoke many things. In fact, those were all very, very appropriate in today's time, with 6 ideas which he gave, 6. In fact, literally, I will take the 6 instructions to all of us, to the legislators, to the various industry perspective, that how to adjudicate the issues, and those 6 ideas we must take it upon so that this can become a arbitration hub once we take these ideas. In fact, Amarjit Singh has very rightly said that India can definitely become an arbitration hub, being such a galaxy of professional lawyers, expert lawyers. I extend my gratitude to Honorable Chief Justice A.K. Sikri and Honorable Chief Justice Deepak Misra and Justice A.K. Sikri for their taking time from their extremely busy schedule. On behalf of CIA and myself, I'm really thank you so much for giving your input in this webinar, and we have very good sessions after this. I look forward to the deliberations ahead. Thank you everyone for your presence. Thank you, sir.
Thank you, Mr. Sethi. Thank you all of you. Now, I think we can start the technical sessions, and Atika will lead. Atika, over to you. You can just set the agenda.
Thank you, Adarsh. Yeah, without wasting the time, I think we are all ready for our next session, which is on limitation on recovery of damages and compensation. We have an excellent panel here, and I'm believing that we'll have a very insightful and interesting session. Let me just introduce all the panelists. I'm assuming they all have joined us right now.
Yeah.
Yes,
Atika,
so let me take the honor of introducing. Others, sorry, I lost you in between.
No, I am saying just give a 2-3 minutes break till the time all panelists joins. I think all have joined now. Session 1 panelist.
No, they are joining. Yes.
Yeah.
Yes.
Just give them just 2 minutes. I think
we have Mr. Mohan Pillai, we have Mr. Gaurav Banerjee. Yeah.
Yes, Mr. Ratan Singh has joined.
He's also here.
Mr. Pillai has joined, and I'm anyway here.
They all are here, Adarsh.
Yes.
Yes, so I believe we have slightly behind schedule, but we are going to take half of the break if need be and make sure
Yeah.
our discussions are insightful and interesting and we come forward with ideas and suggestions. So we have with us Mr. Ratan K. Singh, who's senior advocate and an international arbitration practitioner based in Delhi. He joined Indian Bar in '96 and is one of the leading arbitrators and counsels who's appointed and engaged in complex, high-value construction, engineering, and commercial litigation and arbitration. With about 25 years of experience, he has a heavyweight practice in India as well as internationally with specialties in construction, engineering, infrastructure, mining, joint ventures, franchisee, and others. Mr. Singh has received several arbitral appointments as chairman, co-arbitrator, and sole arbitrator, and has represented parties in arbitration under the rules of ICC, Singapore International Arbitration Center, the GCA, the Delhi International Arbitration Center, ICA, Indian Council of Arbitration and Dispute Resolution, and many others. He is founder and chairman of India branch of Society of Construction Law UK and director of India branch of Chartered Institution of Arbitrators UK. He has 5 international fellowships to his credit. He also has, he's the only fellow from India out of the total 51 fellows from across the globe at International Academy of Construction Lawyers, which is headquartered in US. Mr. Singh has frequent speaking engagements in conferences and seminars in India and abroad. And he regularly delivers distinguished lectures to a variety of audience, from students to experienced professionals and practitioners to executive members of corporate giants. Internationally, he's delivered speech in US, UK, Singapore, Malaysia, Italy, Spain, Brazil, Nepal, and many more countries. He has also several publications to his name, including a chapter on construction arbitration, peculiarities in principle and practice, in emerging trends in our international arbitration, and a handbook on arbitration practice and procedure. We welcome you, Mr. Singh. Thank you for joining today. We also have with us Mr. Mohan Pillai. Let me take a minute to introduce him. Mr. Pillai is head of office of Vincent Masons and Pillai and a Singapore UK qualified disputes lawyer with over 3 decades of experience in advisory, commercial litigation, and regional arbitration work. He's a chartered arbitrator and has been appointed sole and presiding arbitrator and mediator in domestic and international matters. He also appears as lead counsel in the Singapore High Court, Court of Appeal and Arbitrator's. He was in the first batch of senior specialist in building and construction law, accredited by the Singapore Academy of Law in 2018. Mr. Mohan is a general editor of Singapore Arbitration Journal, twice yearly publication of the SIAB, co-published with the SAL. His past appointments include President and Honorary Treasurer, SIAB, co-chair of the Dispute Resolution and Arbitration Committee, Inter-Pacific Bar Association, chair of Society of Construction Law Singapore and the International Construction Project Committee, IPBA. His teaching appointments include Associate Professor, Faculty of Law, National University of Singapore from 2003 to 11, and Visiting Professor, Center of Construction Law and Dispute Resolution, King's College, London from 2005 to 2011. We welcome you, Mr. Pillai. Thank you for joining us. We also have with us Mr. Gaurav Banerjee, who's senior advocate practicing mainly before the Supreme Court of India, as well as an arbitrator and arbitration counsel in a large number of domestic and international commercial arbitrations. He has represented the Republic of India in its investment treaty arbitrations. He's an overseas associate of Essex Court Chambers, graduating from the University of Cambridge in '89 with first-class honors. He was called at the bar at Lincoln's Inn in 1990. He was designated as a senior advocate in 2003 and served as an additional Solicitor General of India from 2009 to May 2014. In his capacity, he represented the Government of India in a number of landmark cases. His practice before the courts is mainly in commercial matters, particularly relating to arbitration and contractual disputes. He has been a part of various government and intergovernmental committees and assisted the Law Commercial in its reports relating to arbitration. Presently, he is representing a number of multinational conglomerates, such as Amazon, in its dispute against the Future Group. Mr. Banerjee, we welcome you as well. Thank you for joining. We have with us Mr. Adarsh Kumar, who's partner at Pro Ultimas, a renowned Indian construction claims and dispute resolution consulting firm with offices in India and the Middle East. The company boasts itself having part of the many domestic and international construction and engineering arbitrations as expert witness. Mr. Kumar has close to 2 decades of Indian and international experience involving project conceptualization and planning, technical and financial evaluation, engineering and construction management, contract management, risk mitigation, claims and dispute analysis, resolution, arbitration, and litigation support, including expert testimony. His project experience includes oil and gas sector, power, petrochemicals, road and highway, pipeline, real estate, having cost range from USD 50,000 to $1 billion of dollars. He's an expert in developing schedule, delay analysis, evaluating delay damages, and an advisory and consulting capacity. Mr. Kumar is a certified project management professional, graduate in mechanical engineering from NIT Warangal, an MBA from Symbiosis, and Master of Business Law from National Law School, Indian University. He has a blend of legal, engineering, humanitarian, administrative expertise on construction projects. He was earlier with KPMG, and in his role, he led team responsible for advising clients on project and construction management for greenfield capital projects. He had also worked with L&T, General Infosys, and MRPL. We welcome Mr. Kumar.
Thank you.
Last but not the least, we have with us Mr. Amit Bansal, who's partner with Deloitte Forensic Practice in India. He leads economic advisory, antitrust, and dispute and litigation support services. Amit brings with him of 25 years of experience and has worked on some large and complex commercial disputes cutting across sectors, predominantly in infrastructure, construction, oil and gas, real estate, mines, and mineral sectors. He's worked on commercial dispute engagement requiring expert intervention in computation of claims as expert assessment, counterclaims, forensic audit, financial statement, termination of commercial contracts, and so on. The report from some of those engagements have been submitted in domestic arbitrations, litigation, and mediations, as well as for international mediations and arbitrations. So I welcome all the panelists today, and this is going to be close to a 65-70-minute session. Mr. Singh, since you would be moderating, I'm going to alert you when we have 10 minutes so that we can move towards closing of the arguments and discussions. To the participants, may I request, in case you have any comments, please put them in the chat section and we'll take them towards the end. If you have questions, you can put them in the Q&A section and we'll try and take it up towards the end of the session. Mr. Singh, should I pass it on to you? Over to you. Yeah.
Yeah, sure. Thank you, Atika. Thank you for kind introduction of the panelists. And good morning, everybody. I must thank the organizers for having all of us, all the panelists. It was a great start of the day with very eloquent talks given by the speakers who have just finished the inaugural session. I have been asked to moderate this session, technical session. Very briefly, I'll outline the structure of the session. Total duration, as Dika said, is 1 hour, 15 minutes. And each speaker will take broadly 10 minutes to give their thoughts on the key themes of the sub-themes which are allotted and assigned to them. And thereafter, we will have Q&A where we will take few questions depending on the availability of time. So anybody who wants to have questions can type your questions in the chat box. And we do not intend to take questions in between because it comes in the way of the flow of thoughts of the speakers. And so as I said, I have got a fantastic panel with me today. So our first speaker of the session would be Mr. Mohan Pillai from Singapore, old friend, and one of the most popular names from Singapore for construction law and construction arbitration. So to kick off the session, we shall hear from Mohan about notice and filing requirements. This is a very important topic, as I said. And this is a staple feature of almost all construction standard forms. FIDIC has this, and even for EOT as well as for compensatory claims, you have to give 28 days notice. That was FIDIC 99 form. And broadly, the notices requirements fall under two categories. One is for time, another is for money, for variation, for compensation, for occurrence of force majeures. And sometimes if you do not give your notices, you sometimes forfeit your rights for recovery or for so on and so forth. So main purpose of all these notices are that employer is made aware of the difficulties arising in completion of the works, and employer can address and consider the issues as and when it arises. So this is an important, very important topic, which is very seldom overlooked by lots of the contracting parties. So that is why we thought that we will have one of the experts in the field who can really tell us his thoughts about the notice requirements. So over to you, Mohan. Over to you.
Thank you very much, Ratan. Good morning, everyone, from a warm and rather humid Singapore. I am delighted to be able to join all of you, and in particular, this very esteemed panel in kicking off the first session on this two-day international webinar event. And my thanks to CAI and Pro Ultimus, and in particular, Adash Kumar, for inviting me and allowing me to participate in this event. Adash, could you make me the host so that I can then share content?
Yes, Vishwanath, could you give a presenter right to Mr. Mohan Pillai so that he can present?
Given, sir.
Yeah, okay, thank you.
Okay.
Mr. Pillai, you would be able to present now.
Right, thank you. Hopefully you can all see my slides now.
Yes, visible.
Thank you very much. As Ratan has mentioned, I will be talking about the topic of notice requirements, and in particular FIDIC, because that is a prevalent contract form. And I'm going to be touching in the next 10 minutes or so on what I call the three W's. And this is, why are notices important? And Ratan has touched on it very briefly. The second I'm going to be looking at is what exactly it is that you are required to give notice of. And that's going to be fairly straightforward. I will be spending a little bit more time on the third aspect, which is when are you required to give notice? And that ties in some respects with the first point, which is why it is important to do so. So with that, I touch on the first of the three aspects I will be covering in the course of this morning, why it is significant. And the short answer is because of the effects of non-compliance. So let me try and elaborate a little bit on that. And what you see on the screen are the provisions which I've extracted from the FIDIC 1999 Red Book. And you can see in the bold print, which I have yellow block, the word shall. And then, you will know almost immediately, either from the fact that as a lawyer, you will know the importance of that, or as a contract administrator, when the word shall appears, that is a mandatory requirement. And in 20.1, there is a mandatory obligation for the contractor to give notice for any claims it wishes to make for any extension of time or additional payment. But what follows in 20.1 is what underlines the significance of this. What happens if you don't? And 20.1 makes it very clear. If you don't give the notice within time, the time for completion shall not be extended and the contractor shall not be entitled to any additional payment. That's the first consequence. It follows from that, and the contract clause makes it very, very clear. The employer is discharged from all liability. So you will lose as a contractor any entitlement to what could be a perfectly good claim with significant prospects of recovery. The legal effect, as lawyers will term such a clause, is it operates as a condition precedent, meaning you must satisfy this clause before any tribunal will look at the merits of your claim, whether it be good or bad. But if you don't get through this gateway process, you will not be able to put the merits of the claim before the tribunal. And that then brings us to the next slide, which is what is it that you give notice of? Now, this is fairly straightforward. You are required in the FIDIC Red Book to give notice of the event that gives rise to the claim, what I call the claim notice. But you also have to then provide additional supporting particulars that are relevant. But that is something that follows 14 days after you've given the claim notice itself. So what is key here is that you must alert the employer that you are giving notice of a claim and the event or the circumstance that gives rise to the claim, although the details of the claim and the supporting particulars can follow shortly thereafter, but there is a time limit of 14 days for that. Which then takes me to, I think, what is a very substantive aspect of notice. And that is, when do you give the notice? Now, there is a timing aspect to this, which is absolutely critical. And it is critical because the failure to comply with that timing requirement will, as you have seen, because this is a condition precedent, mean that you would lose all entitlement to the claim. And that is certainly not a position you want to find yourself in at all. So let's take a look at this issue of timing. And then there are two points I will touch on this in the particular context of whether it is timing that is going to run from when the event has already occurred, meaning retrospective, looking back, or does the timing begin to run when the event hasn't occurred yet, but when you know it is going to occur? So let me deal with this. 20.1 provides that the time period that you have to deal with is 28 days. But 28 days from when? And it is 28 days from when the contractor becomes aware or should have become aware of the event or circumstance. Now, the event or circumstance that is mentioned here, taking in the context of just delay for the moment, it could involve an event or circumstance that's going to trigger delay at some point in the future. So the event has occurred, but the delay hasn't yet occurred. You know it is going to occur. Now that's prospective delay. It's delay that is going to occur ahead of you, hasn't yet occurred. Or the event or circumstance could relate to a delay that has already occurred. And that's retrospective delay. Now this is an important point to resolve because the 28-day period will begin to run from the correct answer to this question. So let me take a look at an example which will illustrate this point. So let's assume that you are in a contract where in June of the year of the contract, the employer issues a change order or a variation order. It's not immediately obvious whether this is going to have an impact on critical delay. But some 4 months later in October, it becomes clear to the contractor that there will be critical path delay caused by this variation. But the delay hasn't yet occurred. That occurs only the following month in November. And that's when the actual critical path delay caused by the variation occurs. So the question that arises in these circumstances is, when does the 28-day timeline begins to run? Does it begin to run when you were aware that the delay was going to occur, i.e. in October? Or does it only begin to run in November when the delay has actually occurred? And that could make a big difference. Now, in the FIDIC Red Book, as I said, the clause 20.1 provision talks about the contractor giving notice not later than 28 days after the contractor becomes aware of the event or circumstance. Now, for extension of time provisions, what is an important provision to look at is clause 8.4. And 8.4 provides that the contractor shall be entitled, subject to clause 20.1, which you will see just in the top end of the slide, to an extension of time if and to the extent that completion is or will be delayed by any of the following causes. Now, the key here is delayed or will be delayed. Now, there is some missing words that is not found in the FIDIC form. It doesn't say whichever is the earliest. It just says so long as completion is delayed or will be delayed. So you've got here an option without the contract giving a priority to whether it is the earliest of the two. And this was a matter that came up for consideration in the English Technology and Construction Court before Justice Aikenhead not so long ago in a decision called Obrascon, which involved a road project involving the airport in Gibraltar. And the court was asked to consider this very question. And Justice Aikenhead said, when you're taking a look at the meaning to be given to event or circumstance, the court took a fairly sympathetic attitude towards it and said, look, there's no reason why this clause should be construed strictly against the contractor. And the judge said that because he said the consequences of not complying with this clause is very, very serious, because you could otherwise have a very good claim. So there's no reason to be overly strict against the contractor. And the court said clause 8.4, in fact, did not impose any restriction by stipulating that the notice must run from when the delay actually occurs or will occur, by saying you've got to take the earliest of the two. So what the court said is actually you can wait for the later, I beg your pardon, the later of the two periods, because the contract clause doesn't force you to pick the earlier of the two. So going back to this example here, the 28 days could in fact run from November, even though in October the contractor already became aware. And of course, this is going to turn very much on the terms of your contract, but on the FIDIC provisions of 1999, under 8.4, you are entitled to wait for the actual delay to occur. And that's an important point to bear in mind. So I'm going to close now with some key takeaways on the issue of notice. First, on significance, as I've mentioned, the critical aspect of why this clause really deserves a lot of attention is that if you do not comply with the timeline, you lose your entitlement to the claim. And it may be a perfectly good claim. The contents of the notice, what is it you give notice of? That's fairly straightforward. I don't want to touch on that too much. I put that up on the slide already. The key, I think, is understanding when you have to give the notice. And although it is not later than 28 days, the critical element is when does the 28 days begin to run? Do you look at it from a prospective basis or a retrospective basis? And with the FIDIC form of contract unamended, you have the benefit of the Obrascon case that says you can actually wait for it, for the delay to take place, i.e. you can look at it on a retrospective basis. So with that, thank you very much for your time, and I'll pass this back on to Ratan.
Mohan, very well, very good presentation. I know we are running late, but I'm tempted to ask a couple of things. Do you think that such requirements, notice requirements in the manner we see in FIDIC forms, really promote a necessary commercial purpose? Or are they too strict and can result in adverse consequences of barring otherwise valid and good claims?
I mean, the second point is almost certainly true. Non-compliance will have a serious and clearly prejudicial effect on the contractor in barring what could otherwise be very good claims, which does raise the first point you mentioned, Ratan. What is the commercial benefit of providing this? Is this designed to be punitive? Is this designed to punish the contractor? Or is there some legitimate purpose that these clauses serve? And I think the conventional thinking, and you'll see this in a number of court cases, is that especially when you are dealing with consequences that are going to be visited upon the employer in terms of time and in terms of costs, this serves a legitimate commercial purpose in allowing the employer to understand that there are now a very serious prospect of delay taking place to the project or significant additional costs, and therefore gives the employer an opportunity to consider how to respond to that. He may wish to continue with the project with the risk of that, or he may decide that with these consequences now being alerted to him, he may want to alter the position to contain the possible impact in terms of time and cost, and change or reach a discussion with the contractor on how to manage this particular process before all of this end up being visited. So I think most courts now generally take the view that there is some benefit and there is some commercial purpose that is served, and it is really therefore for the contractor to either negotiate out of the serious consequences of the clause, or if he doesn't, then he will be expected to comply with the provisions at the risk of losing what would otherwise be a very good claim in case of non-compliance.
Mohan, I'm conscious of the fact that many jurisdictions all across the globe enforce such clauses, and they find these clauses to be enforceable clauses. However, Indian position is slightly different. Under Indian position, Section 28 of Indian Contract Act does not recognize these notice requirements to be enforceable clauses. And it is considered, these notice requirements are considered to be in restraint of legal proceedings. So Section 28 is really makes such clauses unenforceable so far as India is concerned. There have been lots of debates. We had the Law Commission's report, which dealt with the Section 28 issue. Question is, the Section 28, it has certain legitimate purposes because it wants to ensure that the general consumers are not deprived of their legitimate rights in the hands of big commercial giants. But at the same time, where contractor and employer, where both sides are duly advised by legal team and they are commercial parties, why they should not be bound by such clauses. So do you think that this Section 28 position which we take in India needs a relook either by the legislature or by the courts?
I don't want to presume to be advising on aspects of Indian law. I'm not qualified, and there are people on the panel and certainly someone like yourself who are eminently far more qualified to deal with that. But I think for parties who are interested in making this a live issue and interested in relying on whatever protection is available under Indian law, the key to this, certainly, when I sit as arbitrator, the key to this is going to be what's the governing law of the contract. If the governing law of the contract is, English law or Singapore law, and the parties don't choose Indian law, this is not going to be a live issue. But, it will be a live issue if the choice of law provision for this particular contract ends up being Indian law, and then Section 28 may well be relevant. And, whatever views one may have from a commercial point of view, if that is the proper legal interpretation of Section 28, then I think a tribunal will say a contract governed by Indian law must therefore comply with Indian law. And if the proper reading of Indian law is that Section 28 does not allow Clause 20.1 to operate as a condition precedent, then I think that is what any responsible tribunal will find.
Great. In fact, my suggestion and my thought is that Section 28 should take differential treatment for two categories of cases. One category of cases where you have innocent consumers. There, Section 28 as it is can take care of that. But where you have commercially prudent parties, there I think there should be differential and different treatment. That is what I might think. So thank you very much, Mohan. As usual, you were fantastic, and I'm sure the audience would have greatly benefited out of your talk. Thank you very much. Now we have one of our legends, Mr. Gaurav Banerjee, and I can't see Mr. Banerjee on the screen. I don't know why. Let me
If
check.
I could ask Mr. Pillai to end the screen,
Yeah,
you would be able to see all the panelists. Yeah.
Okay, just give me a moment. I'll deal with that.
Yeah.
Now I can see Mr. Banerjee very well. Mr.
Yes,
Pillai
okay.
started his talk and concluded his talk with W's, what, why, when. The same goes with the prolongation claims which Mr. Banerjee is going to touch upon. Because every claim, prolongation claim, must address 6 and 5 W's. Who, what, where, when, why, and followed by how. So prolongation claims are like pandemic for construction industry. Any impact on critical path milestones will delay the completion date, and impact on non-critical milestones will result in inefficient working, but not in later delay the completion date. So prolongation claims are basically loss suffered due to compensable delays. So these, while preparing the claims, or what all is, and actually these are the typical claims which wherever you have delay claims, wherever you have delay claims, the claims like what we are going to hear from Mr. Banerjee are always there. So I'll request Mr. Banerjee to enlighten us with his past experience in this field, and let us go to hear Mr. Banerjee. Over to you, sir.
Thank you, Mr. Ratan Singh, my good friend. Thank you to the CII. Thank you, Adarsh. Without further ado, since I have 10 minutes and I intend to keep to the timeline, let me say what I would like to discuss, so that at the end of 10 minutes, perhaps you have some guidelines or signposts as the audience to take away after this discussion. So the two topics that I've been given, one, of course, is prolongation, but fortunately not all of prolongation, because that is will result in a very prolonged presentation by me. The only area that I have been asked to discuss is the recovery of head office costs. And the second aspect is on acceleration claims, which I'll come to in a moment. So the issue here is that we day in and day out deal with prolongation claims, and I'll try to answer the question that Mr. Singh posed, which is the how do we deal with this? Now, the first issue regarding this head office overhead is we all claim it, but we are ourselves unsure as to how do we quantify this claim. Because head office overheads essentially represent general administrative costs in setting up and resuming a contract. And then if there's any delay or disruption, there's an aspect of loss of profit, which the organization would have made had the prolongation not happened. So everybody here knows the general principle of head office costs. But the fact is that it is impossible to calculate this precisely. We have lots of delay experts who have different views on this. So then the question is, at least in India, we take the easy route. The earlier way, so the way I want to go about this, I want to mention a few judgments which you might note, so that if you have a problem, you could fall back and refer to them. So in India, the first approach was that you had a simple figure, 15%. That famous case of A.T. Brijpal Singh in 1984, 15% loss of profit, bung in the formula, make the claim, and hope to get it. Then there was a little more sophistication. In the McDermott case, McDermott-Burns standard, I had the privilege of appearing in the arbitration, which is a judgment of 2006 of Justice S.B. Sinha, as he then was. And there he discusses, the classic Hudson formula, Emden formula, Ickley formula, and then ultimately he says, well, we leave it to the arbitrator. Now, what is the trap here? The trap is that the easy route to take is to rely on a formula. And the trap here is that there are at least two judgments, and I'll mention the judgments, which say that reliance on a formula is simply not good enough. You have to produce some material. Obviously, that's difficult, but you have to produce some material. And there's a very interesting case of the Punjab and Haryana High Court. And it arose out of this highway between Karnal and Ambala. And it's the state of Haryana versus joint venture of Unitech. It's a judgment of 2016, where essentially the judge says that, look, great, the arbitrator has used the Hudson formula, but I am going to actually set aside the award. And he proceeds to set aside an award, which is quite a drastic step. And he relies on an older judgment of the Bombay High Court, authored by no less than Justice D.Y. Chandrachud, in a matter called Edifice Developers versus SR Projects. And the theme of both these judgments is you simply can't rely on a formula. You have to produce some material. So this is the first cautionary tale, that how do you make this claim, which is of course quite a difficult claim. So that's point one. Point two is even more problematic. Which formula will you use? Do you use the Hudson formula? Do you use the Emden formula? Do you use the Ickley formula? Do you use a different set of formulae? That is now a little tricky. But there, what I would say to you is that the guidance that we get about what is the way to go comes from English judgment, because unfortunately we have awards, but we don't have judgments. And English judgments, now of course you have the technology in construction court, but English judgments do throw light on this issue as to which formula is to be used. And just by way of flagging some of those judgments, I'm mentioning one judgment which actually deals with all the other previous judgments. It's called Norwest Holst Construction versus Cooperative Wholesale Society. It's a 1998 judgment. There the judge discusses all the formula. He discusses the earlier judgment of Alfred McAlpine, which is the leading case. And he then works it in, and he shows you how each of those formulae operate. So, you have to see how each of those formulae fit into your particular case. So that's the second major aspect to be seen when you deal with overheads. The third aspect that I want to highlight is that the theory is that you could have recovered monies from elsewhere. So you have to put in some evidence. You may have bid for another tender. You may have failed for another tender. You may have taken on more people at your head office. You will have to show some methodology by which you can justify some of the extra cost and the overhead cost. In fact, Hudson says that this category only came into place because it started discussing this in its 10th edition. But it is a category, and it is a claim that is to be made, and it is a genuine claim. The only caution is to delay experts, to contractors, that you must produce some material. Don't leave it to the formula, and don't leave it to the lawyers. So I'll quickly move on to the second aspect, which is acceleration claims. Now, what is this creature of acceleration claim? I'll give you a concrete example, and then you can see how to fit it in to your particular situation. This is an unusual claim. An acceleration claim, and I'm giving you a concrete example in which, in fact, I had appeared, was the contractor was asked to participate in this brownfield project, which was an oil refinery. And in that oil refinery, obviously, oil was being produced, and they wanted to expand the refinery. And the employer suddenly in the middle said, look, Mr. Contractor, I know this is the pattern and this is the work you have to do, but I want you to accelerate A, B, C, D, because if you do A, B, C, D earlier, I will definitely be able to extract more oil and gas. So in that sense, typically acceleration claims are in a situation like that. Again, unfortunately, we do not have much, shall we say, knowledge or judgments on this. But the leading case on this, in fact, is an American case called Norair Engineering, and it explains the situation where such a claim can be made. and in NORAIR, the three conditions, I'll just read it out to you, it'll be easier, is that any delays giving rise to the order were excusable. So this is after you get an acceleration order. 2, the contractor was ordered to accelerate. And 3, the contractor in fact accelerated performance and incurred extra costs. Now, this is a difficult claim to prove. The US is much more accepting of it. The UK, many claims have failed, but there's a delightful case which I will mention, called Cleveland Bridge. Again, Justice Aikenhead, I think Mr. Pillay mentioned Justice Aikenhead, the Technology and Construction Court, and he gave such a claim. And the interesting thing about this case was, it was to do with the Shard. Those who you visited London, it's the tallest building in Europe. It's supposed to look like a shard of glass. And Justice Aikenhead, in his judgment, it's called Cleveland Bridge UK Limited versus Severfield Rowan Structures, actually analyzed the acceleration claim and gave some of these claims. Interestingly, this is a topic which is not restricted only to the UK or even the US. There are Australian cases, there are Canadian cases. There's a case in Australia called Perini Corporation. There is a case in Canada called Morrison Knudsen. If required, I can give all the references and you could have a look at it, since I have exceeded my 10-minute time. The idea is that whenever you make such a claim of acceleration, again, the benefit of some of these judgments is you get a template as to how to make such a claim. What are those claims which are going to work? What are those claims which are not going to work? One of the most common journals in England is called Building Law Reports. That's one of the most common journals. And what is very interesting about Building Law Reports is there's a little commentary of 4 or 5 pages by the editors of the report. And if you take one of these cases and read the 4 or 5 page commentary, they will give you a broad view of the topic. So all one can do in the 10 minutes that is allocated is essentially to have some flag posts to point you in the right direction and to caution you that please don't trust the lawyers. Please produce the material to justify your claims. Thank you.
Thank you, Mr. Banerjee. Thank you, Mr. Banerjee, for really taking us to the nuanced aspects of prolongation claim, particularly the overheads, and taking us through the Punjab and Haryana High Court judgment, which relies upon Justice Chandrachud's judgment. And we do have a couple of other judgments, one Delhi High Court judgment written by Justice Bhatt, and one judgment of Madhya Pradesh High Court that also says exactly the same thing what you said. In fact, just to add to what you said on acceleration, SCL protocol, Society of Construction Law Delay and Disruption Protocol, SCL protocol, the second edition, the code principle 12 talks about acceleration cost very beautifully. And in fact, rather it defines this. It says acceleration is a subset of mitigation and typically refers to the situation where additional costs are incurred to seek to overcome all or part of delay or disruption. So anybody who is not aware of SCL delay and disruption protocol, I must say this, I'll encourage all the participants to, if they have got anything to do with construction disputes and construction law or construction disputes for that matter, they must consult this best written document, which is SCL delay and disruption protocol. It is freely available on SCL website, not on India website, but on the UK website. So this is one thing which you must keep this in mind. And I would say, as very succinctly said by Mr. Banerjee, that you must have documents. You must have documents in support of your overhead and prolongation claims. I'll just add one thing more. The proper record keeping. How do you really produce the documents if you are not aware of the proper record keeping That is one. And second, updating the program, the baseline program which you have, L1 schedule or whatever you want to call it. Updation of that and proper record keeping, the manner it can best possible way it can be done. And for that, again, I encourage everybody to refer to SCL delay disruption protocol, which tells you the categories of documents which both parties should maintain. In fact, it is appropriate that in the tender documents itself, it should be written that proper, what would be the proper documents, who will maintain what all resources are to be allocated, so that contractor can also consider this and make allowance for that in the bid. So that is one thing in support of, so that it really makes your claim efficient. Difficulty today is, you see invariably, my experience, and Mr. Banerjee will agree with me, experience as arbitrator, what we see is that we have claims being brought before by the contractors, and they say, I'm entitled for this as per this formula, and they just give you one chart, nothing else in support of the claims. It is just impossible to award claims just on the basis of a chart which says that I have applied the Hudson formula or whatever formula. Thank you very much. Thank you very much, Mr. Banerjee, once again.
Thank you
Now
so
we
much.
come to the next topic, that is excusable, non-excusable, compensable, non-compensable claims, as well as accelerate the concurrent delays. For that, we have the delay expert who is going to really talk about this topic. As I said earlier, that I have been also asked to introduce the topic sub-themes for the benefit of the participants. In fact, before I move further, I must say that 2 or 3 months ago, I had occasion to cross-examine Mr. Adarsh Kumar, who is today's delay expert and the speaker today. I cross-examined him for 12 days in a matter which is more than $1 billion claim for a power plant. And I cross-examined him only on methodology of delay delay analysis, which was APAV as plant versus as bill methodology, and we had great time, both of us. So that was not a disclaimer, but I thought I must share with you. And the second thing, what is the role? What is the role of delay experts? I understand Mr. Justice Sikri had also touched upon this a bit. As we all know, the delays are inevitable in construction projects. Now, what happens typically? I'm talking about India. I'm not talking about all other jurisdictions, though it is commonplace that both sides will make allegations against each other, right? They will write emails to each other when claims are presented before the tribunal, or claims and counterclaims. What is brought before the tribunal is, in support of their claim of delay, only emails, apart from some minutes of meeting or some other progress reports. And they expect the tribunal to decide the delay, and they expect the tribunal to allocate delay just on the basis of those emails and some other side documents, which in my understanding is just impossibility, unless it is a very small period claim and there are 1 or 2 activities, very few activities, and you have sufficient document. Otherwise, it is difficult to really allocate delays in appropriate manner. For that, what we need is well-qualified delay experts who have expertise in analyzing the delays. And for that, again, for delay analysis, again, we have some standards, international standards, like SCL protocol, as I referred to earlier. SCL protocols refers to 6 delay method analysis methods: retrospective, prospective, how you have to determine the critical paths, and so on and so forth. Depending on the requirement of the project, depending on the documents you have for the project, you decide which method to go for, and ultimately the delay analyst really decide it. So there is general lack of awareness in India amongst arbitrators and parties about the role of delay experts, which is otherwise in other developed jurisdictions, invariably in every construction claim you will have delay experts and quantum experts. But somehow we need, in fact, I have had experiences where tribunals just refuse to allow the parties to lead evidence and get the experts report filed. So now for that, today we have Mr. Adarsh Kumar. And so now I request Adarsh to share his thoughts on this.
Thank you, Mr. Singh. Can you give me a presenter right also? IT team, CIIT team, can you give me a presenter right? So till the time, actually being as an engineer, we always comfortable with the past point. We don't have such a beautiful auditing skill like a lawyers. So we are much more comfortable to express our thoughts in a PowerPoint way. So I'll definitely take this PowerPoint help to explain all these things. As far as Mr. Singh has already told, I met so many lawyers, advocates, but Mr. Singh is in my best of information and knowledge. Mr. Singh is one of the lawyers who understand all the engineering technical jargons. So although I'm not aware so many other advocates who equally understand all critical path, flows, analysis, and all these things, which is a engineering tools kind of things. So let me just see whether I can share the presentation now. Just a minute. Is it visible now?
Yes.
Yes. So as in the morning sessions, even Justice Sikri has emphasized on a lot of the delay related issues, and delay is a part and parcel of any construction projects. And in fact, in my experience, being as a working in a EPC company, reputed EPC company, and working in a consulting firm, I hardly envisage any project which has completed on time. And I'll show some research analysis also. Before that, just I want to show some of the research things. So India has rapidly growing infrastructure industries which receives huge investment. And the second point, infrastructure projects involve multi-party entities engaged in a different scope of work, which leads to the complexity in execution of projects. All infrastructure projects, like be it a railway, be it a metro or a power plant or oil and gas, all are very complex in nature. And delay in disputes in construction project is due to the involvement of multiple entities. So in most of the infrastructure projects, like subcontractor, engineer, quality people, a lot of people are involved. So obviously it leads a lot of complications also. So I just go to the key data research from the internet. The construction industry is having a significant role in the national development, and it contributes about 8 to 10% to the national GDP. And the second point is a very, very interesting, more than 2 lakhs crore money in construction dispute. Of course, I don't claim that this figures is absolutely correct because it is a research from the public domain. It may be here and there slightly. And the third, also, it is a very, very important aspect and a research that 95% of the project is having a schedule or a cost overrun as per the PMI USA data. So it is likely to, any delay dispute is likely to be happen. So that's why I said that in my experience, I've never envisaged that any project has completed on time. So all the projects is having a schedule or a cost overrun. And the fourth one is the delay damages are the major portion of the claim in construction infrastructure dispute arbitration. So everybody, since in the inaugural sessions also, Justice Sikri has also emphasized that most of the infrastructure projects dispute arises because of the delay. And there is a repercussion of the delay which gets into the claim part. So I'll just try to finish in 8 minutes because we are running behind the schedule. So I'll broadly categorize the cause of delay claims, because what is the cause of delays is a very important. And being working in EPC firms, we understand the psyche of the contractor, employer, subcontractor, and other stakeholders as well. So owners representative related factors. So most of the what we have experienced, we called in our parlance called as a delay events. So most of the delay events, what we emphasize, delay in handing over the site, which is broadly into the road sector projects. And I believe in NHI projects, this is the dominant delay events, especially in NHI and metro projects. And delay in payment to the contractor, which is a second factor. Excessive changes or change order, which leads to a variation claims, which itself a big topic. And delay in design drawing approvals and vendor approval. This is also many times happens, especially when the other site is a PSU or a government client. They have a lot of set protocols. So suddenly, if you want to change the vendors or you want to change some drawing, so it takes a lot of time, and which exceeds from the approval cycle time, and the slow decision from the owner. The second factor is the contractor related factors. So poor planning by the management and a contractor financial issues, because the cash flow issues always happens with most of the small contractor and middle size contractor. So this is one of the root cause of the delay. And the execution error leads to rework. So this is also a very important thing, that it leads a lot of dispute because of during the execution of the projects, there is because of the drawing change or manual intervention or anything related to contractor. Sometimes it goes into the rework, which increase the time of the projects of the execution time. So common cause of delay in the EPC contracts. So what I said, that delay duration engineering so there are 5 EPC engineering, procurement and construction law. Most of the large infrastructure projects is divided into the 3 phases, or basically in a 4 phase: engineering, procurement, construction and commissioning. So EPC is a very famous name. So during the EPC phase, delay occurs at the engineering stages. So engineering stages delay related to the drawing change and all. And then second stage, which is a procurement and a contracting phase. This also leads to a lot of delay because the vendors approval or LC or any kind of financial things or these kind of things happens during the procurement and subcontracting phase. And the third one is which is largely happens during the execution of the time, which is a construction related delays. So delays during the engineering stages, the delay in approval of design, high number of revisions of drawing based on the comment of the employers. This is the main reasons during the engineering stages, because to and fro comments are going on that. And lack of knowledge of the process, technology, engineering, and experience with the respect to the new work, which is also predominant reasons at the engineering stages delay. And late decision in the various engineering activities by employers as well as contractors and subcontractors. And the fourth point is engineering work may begin later than as envisaged in the schedule. So engineering work sometimes sequencing of the drawing is very important, because as Mr. Singh was also notifying, and Mr. Banerjee also told that what is the critical delays. So many of the time employer and contractor fights on the engineering issues or engineering drawing issues, but all the drawings are not falling on the critical path. Basically, the critical path is a terminology which falls the longest chain of the projects, where even a 1-day delay happens, then the project will be the project completion date will be prolonged by so many days, same days. So critical paths. So we have to understand that which are the drawings falling on the critical path or not falling on the critical path. So identifying a critical delay is very important. So I'm just skipping a couple of the slides because of the paucity of time. Otherwise, the slide has meant for the 12 to 14 minutes, but I believe we have only 7 to 8 minutes. So I'm just skipping a couple of the slides, and I'll come to the key points also. So delay during the procurement and subcontracting phase. These are the basically letter of credit related issues or delay in payment related issues, or late opening of LC, dispute between the contractor and their subcontractor vendors. These are the typical issues during the procurement stage. And the construction stage, as I said earlier, also breakdown of many construction equipment. This is one of the part, and inaccurate work which leads to the rework. And rework is also a majority of the concern in mostly infrastructure work, like especially in a power plant or oil and gas related project. Many projects always go through the rework phase. The third one is force majeure situation. Like anyway, it's a big topic, so I will not touch upon this because there are so many sessions which will deal about the COVID related issues and other force majeure related issues. And then the last one is delay in commissioning due to the non-availability of trained manpower to take over the project from the employer side. This is also one of the reasons we envisaged in so many delay analysis. This is also one of the delay events and prominent delay events. And delay in the construction and commissioning of the projects. These are the typical regions which usually occurs in the construction projects during the time of erection and commissioning of the projects. I'll skip this. Other delay is the EPC contracts. This is the unilateral termination of the contract. Of course, this is not related to the delay. This is a different kind of dispute, but this is also leads to a related to the delay only. So financial problem of a stakeholder with whether temporary or a permanent terms, insolvency of either employer or a partner in the consortium of the contractors, project being kept on hold by the employer. This is also many stalled projects in the NHAI where the project has been stalled, and that is why you might have observed, and many people have observed, that the delay damages is 2 times the project value also, which is looks like irony. The project value is 1,000 crore and overall claim is 2,000 crores, which is the 2 times of the project value. This is basically reason because the project becomes stalled, and during the stall duration, contractor claims the all prolongation claim, what Mr. Banerjee has explained. I'll quickly complete another 2 minutes. Delay can be attributable to the following: delay by the employer, delay by the contractor, delay by the subcontractor, and delay due to the force majeure. So I'm just coming to the topics. I'm skipping this CPM scheduling part also because of the paucity of time. I'm just coming this the main theme. Actually, the purpose of this, that first we wanted to elaborate that what are the root cause of the delay, and then we want to say that what kind of typical delays are there. So typical the sub-theme of the topics are like excusable and compensable delay. So excusable delay is that delay where the delays that entitle contractor to time and cost and are not attributable to the contractor. So generally due to the delays solely attributable to the owner. So this is our core analysis, and this is our USP. When any delays happens, there is a factual things. What was the contractual completion date and what was the actual completion date? And actual completion minus contractual completion is the overall delay of the project. But argument starts ki who has delayed how much. Like this is the most important things to attribute the delay between the contractor and an employer. Let's say 100-day delay is there. So how many days attributable to the contractor, how many delays attributable to the employer, and how many is the concurrent delay where both the contractor and the employer are delaying parallelly. And participants should not be confused with the concurrent delay, because concurrent delay is always to be looked into the critical concurrent delay. Basically, there's always the delay is a part and parcel of any projects. But as I said, that every delay is not a critical delay. Which contributes on a critical path, those delay can be considered as a concurrent delay, where the employer and a contractor delays are both simultaneously falling on the critical path. So the second type of delay is excusable and a non-compensable delay. So this is the delay that allows extension of time to the contractor without any liquidated damage, but no additional cost for the extension. So for the benefit of the projects, most of the time employers gives this extension of time to the contractor, but they put a disclaimer that they reserve the right to the LDs or no compensation or something like that, which is a provisional extension of time, and that is the root cause of merely dispute arises the dispute post completion of the projects. Of course, for the benefiting of the projects, during the project, contractor or employer does not fight. But once the projects get finished, so this is the mainly root cause, because contractor, end of the day, contractor always wants a claim, because they have also incurred a lot of losses because of the prolongation. And the third one is inexcusable delay, where contractor to be penalized, which is solely attributable to the contractor. For example, the contractor has delayed in mobilization, or slow progress, or loss of productivity, or anything. So this constitutes inexcusable delay. And the last one, which I said, that concurrent delay, so delay is attributable to both contractor and taking place concurrently, and it should be looked on the critical path. Though I have a lot of slides, but I'll try to skip here because of the paucity of time. So I just try to conclude this my presentation here only. Thank you, sir. I will send the slides to participants later, because there are other things also, but because of the paucity of time, I cannot explain right now. Otherwise, other speakers will not get appropriate time to explain his thoughts.
Thank you, others. It was very good presentation. Delay analysis is a vast subject, so it cannot be covered in 10 minutes, as you rightly pointed out. But you have touched upon some of the relevant aspects, such as critical delays, non-critical delays, excusable delays, non-excusable delays, compensable delays, non-compensable delays. These are broad areas which could have been covered within such a time. Thank you very much. Now we are going to another expert on the panel. We have just heard delay expert. Now we are going on to another expert, Mr. Amit Bansal. He is the quantum expert. Invariably, what is seen in Indian scenario, and Mr. Banerjee will agree with me, that parties devote their substantial time in establishing the liability. But when it comes to quantification of the claims, very little attention is given to that. And what we finally get to see is few charts prepared or some self-serving documents. So quantification as such is missing. Supporting documents are missing. So even if a party succeeds in establishing liability on the part of the other side, how do you expect an arbitrator to award you the claim, and how quantification will happen? Sometimes it is a general grievance that in India, arbitrators are generally not awarding huge damages as happens in various other jurisdictions. And I would say this is one of the reasons. Unless you substantiate your claim properly, unless you analyze your claim properly, you cannot get the compensation. You have to give that confidence to the arbitrator that yes, this is my claim, this is how it is substantiated. Otherwise, what's happening is parties are simply throwing away good money that they could have been awarded had they prepared claims after availing expert quantum analysis and their services. It is not happening. See, issues such as lost profit. This is not something lawyers can really prove and work on. These are complex quantification issues. The kind of data you have to see, the international data, the national data, the regional data, all of this. Then you have to see the market. So many, there should not be any duplicacy. I have had occasion to have on my board lots of international quantum experts, and what I have learned is that when it comes to complex quantum issues, it is better to have quantum experts so that they are not only independent, they also give confidence to the tribunal, and they bring on board lot of value, which ultimately helps the tribunal. So with this, now I'll request Mr. Amit Bansal from Deloitte, one of the very popular names in this circle. So over to you, Amit.
Thank you so much, Ratan Singh ji. Thank you so much for your generous words, and a very good morning to all my co-panelists and all the audience. Adarsh, could you request the CII team to keep in the presentation, please?
Vishwanath, just give him a presentation, right? Or Rhythm, whoever is there. Are you able to see, sir?
Yes.
Okay, fine. Go ahead, sir. Go ahead, Amit.
Is everyone able to see my screen?
Yes, yes.
Yeah.
Yes,
Okay, so
visible.
everyone has made my task easier, right? From Mohan, then Gaurav and Ratan Singh ji and others. Now I need to kind of just pick up the threads from there and see how those threads need to be tied up when it comes to quantification. The and I know it's a busy slide. Don't read too much into the slide. The why this slide is important to look at, because there are lots of interdependencies and correlations between various events. Now, invariably, when we look at the statement of claims which has been prepared by by the clients, it will have a lot of positions and assertions with respect to events, with respect to circumstances. And then it will also have a claim, an amount. And that actually will be an amount which would have been incurred. What would be missing is the impact of that event on time and impact of that event on the cost. Invariably, it is an assumption that such an event has happened, and because the cost which you have incurred is higher than the cost which I should have incurred, should be my claim. It is important to demonstrate that. What are the things which are important to demonstrate, and for which we need to have the right set of documents and evidence to be able to do the quantification properly? Dates are very, very important. Mohan mentioned about notice requirements. Of course, yes, that was more about FIDIC contracts. In the Indian contracts, the Indian contracts are not so rigid about notice requirements. What does the notice requirement do? And purely from an expert perspective, it establishes a date on which the meter can start with respect to computation. Yes, of course, one can take another date around that time, given the circumstances or depending upon the circumstances, but availability of such documentation helps experts to identify the claim period, especially in a construction contract where there will be multiple events, there will be multiple impact on timelines. The ability to decipher the impact on timelines for each of the events becomes important. Then similarly, the impact of those timelines into the cost. And that is the role of the expert when it comes to quantification. It's about looking at all the records which tie up to the project schedule, both original versus actual, then doing the calculation basis that. Now, to give you an example, I was working on one of the matters, and I will pick up the example of, let's say, diesel. Invariably, in most of the matters which I have worked on, I will see it is very easy to prove the events, and most of the clients have very strong evidence to prove the event. However, the correlation of that event to the impact on time and cost, that is where the challenge comes in. So as far as impact on time is concerned, that is what the delay assessment takes care of. I will not touch upon the delay assessment bit of it because Adarsh has spoken about some of the aspects. But important thing from a delay assessment perspective is that delay assessment provides us the impact on time. It gives us those dates, as also it provides us the delay is attributable to whom. So these are the two important things which come out from a good delay assessment. There are various methods of delay assessment. I will not go into it. The choice of a right method will really depend upon the circumstances of the contract and the situation at which it is being applied. So like any formula, the formula needs to be applied in the context of the situation. So, and the same is true for any of the methods when it comes to delay analysis methods. And coming to my last slide on the quantification basis, but for a key consideration from an expert perspective again is, had that event not happened, what would have been the cost to establish that? Now, invariably, the assumption, I see clients working with the assumption that had the event not happened, I would have been on my budgeted cost. It is important to demonstrate that the client, that they would have indeed been on the budgeted cost to be able to claim the variation over and above the budgeted cost. What we end up seeing most of the times is, there is a baseline schedule which is prepared in the beginning. It is not updated. The project schedule I'm talking of, it is not updated as frequently as it should be to reflect the impact of those events and and hence on the project timelines. The timelines work and the cost, they are interdependent. With the monitoring of that, the practical realities happen differently in a contractor situation. And that is where one of the most important things is to have a fully loaded baseline schedule and monitor that. Basis that, invariably what we will see when we are looking at the evidence from the underlying documentation perspective when it comes to quantification, whether are there any daily progress reports, are there any weekly progress reports, what do they reflect? When I look at the statement of claim, would have taken positions on so many aspects. It could be delay in handing over of the land, delay in handing over a right of way, delay in environmental clearance, there's so many delays. But when I look at the monthly progress reports, they do not reflect an impact of any of those events. And then it becomes very challenging for any expert to actually, work out and try and build in the impact of each of those events if it is not reflected in the monthly progress. I can understand it may not get reflected in the daily progress reports. There is a very good chance that it may not get reflected in a weekly progress report. However, the monthly progress report must recognize that. And those are some of the key milestones basis which, experts like us end up doing our work. We are actually looking for that evidence for the purpose of demonstration that the impact of that event started on such and such date, and then looking at cost. Now, I will give you one last example in the end. I was working on one matter, and all the delay events were very clear. What was challenging for the client to demonstrate was that the increase in cost was on account of all of those events. I will pick up example from one of the points there, the diesel cost. They said the diesel cost was X rupees per liter when we took the contract. Now it is Y rupees per liter. The cost of diesel has gone up. There is prolongation, and hence I should be compensated for Y minus X into the quantity of diesel which I have consumed. Is that correct? I don't think so. Because in absence of the event, also the diesel cost would have varied. What it needs to be compared with, what is the average budgeted cost of diesel which was taken in the budgeted cost? And the variation from that budgeted cost is what will get claimed from a quantification perspective. And with this, this is a topic which I can speak for hours, but this is, I think, good enough to give hints in terms of where, the key lies. The key lies in having the right set of documentation and contemporaneous evidence to be able to demonstrate the impact both on time and cost. Thank you so much.
Thank you, Amit. Thank you. It was really nice presentation, and especially the illustration, the last example you gave about the diesel set. In fact, I'll end this session by saying that in one of the arbitrations, it was a mining arbitration, where mining operations were awarded, entire mine operations were, mining work was awarded to a contractor, and the contract was prematurely terminated. So I was engaged at the later stage, and I said that you need to have, it's all lost profit, you needed to have a quantum expert. So one quantum expert was engaged, and his report was fine. And there again, diesel cost, what would have been then, how it would have progressed, and all of that, Indian market, international market, regional market pricing, international pricing, blah, blah. Interesting thing to be shared with all of you is that the arbitrator, sole arbitrator, refused to take that report on record. He says, who is he? Or who is he? Who is he? What is expert? I don't know. What expert means? Nothing. So there, it is very important that all stakeholders are aware of the role of delay in quantum expert. With this, we are running short of time. Thank you very much, all my co-panelists, for taking our time and sharing your thoughts. Mr. Banerjee, Mr. Mohan Pillai, Mr. Adarsh Kumar, and Mr. Amit Bansal. Thank you very much. Thank you.
My pleasure. Thank you.
Thank you. Thank you
To
very
end
much.
the session, I just wanted to thank Mr. Ratan Singh for his stylistic and inimitable style in conducting the session. Thank you, everybody.
Absolutely.
So kind of you. So kind of you. So kind of you.
Thank you. Thank you, everyone.
Thank you, sir.
Thank you so very much, gentlemen. Yeah, thank you, Mr. Singh, Mr. Pillai, Mr. Banerjee, Mr. Kumar, and Mr. Bansal. This brings us to the end of first technical session. I think, Adarsh, we could take a break of 5 minutes. And is that okay? Or should we take a longer break?
Yeah, sorry, I
Adarsh,
was
I
on
can't
mute.
hear you.
Yeah,
I think we
yeah,
can
yeah,
hear
yeah.
you.
So
Yes.
we can take a
All
5
right.
minutes break, then the session 2 will be start very soon. Okay.
Yeah,
Thank
so
you all of you.
we'll reconvene in 5 minutes. Yeah.
Yes. Yeah. Thanks.
Please feel free to get your cup of tea and coffee so that we can start the next session on time, and it will be on unlawful termination and the encashment of BGs.
Thank
Stay
you very
tuned.
much,
Yeah.
everyone. Bye-bye.
Thank you. Thank you. Thank you. Good morning, all of you. Good morning, all panelists. In this session, my colleague Vandana would compare. So, Vandana, can you introduce? I think Mr. Ajay Bhargava, all the 4 panelists are there. Yes, Mr. Tejas Karia from Sadul Merchants in this panel. Of course, earlier it was Mr. Rishabh Gupta, but due to some exigency, he could not join. Unfortunately, we have Mr. Karia, his calendar was free. So we are fortunate enough to get his last minute entry. Although we have invited earlier in a different session, but his calendar was fully occupied. He was handling a couple of international arbitrations, so he could not give us time. But it was just we are very much fortunate in that sense. So Mr. Karia is here, and of course Mr. Chandyok and Ajay's video is not visible. Mr. Ajay Bhargava.
Yes, thank you, Adarsh.
Yeah. Okay.
Can I begin now?
Yeah, sure, Vandana. I'm putting on.
Very good afternoon to one and all. I now take pleasure in introducing the esteemed speakers of today's session. Mr. Amar Singh Chandyok. Mr. Chandyok is a former Additional Solicitor General of India. He is practicing senior advocate and president in Sol India and president Council for Conflict Resolution Madhyam. He is president of Delhi High Court Bar Association for 6 terms. He is president-elect the Bar Association of India. He is member London Court of International Arbitration and accredited mediator of Singapore International Mediation Institute. Mr. Chandyok has been awarded 2 doctorate degrees. He is an extensively traveled person, both within India and abroad. He enjoys photography, classical Indian music, and films. Welcome, Mr. Chandyok. Mr. Tejas is a partner and head arbitration at Chardul Amarchand Mangaldas and Company. He has a wide experience in handling international commercial arbitrations across sectors. He has represented multinationals and Indian corporations in ad hoc and institutional arbitrations seated in India, London, and Singapore. He regularly sits as an arbitrator. His well-regarded contribution to policy formulation across the arbitration domain involved the drafting of amendments to the Indian Arbitration and Conciliation Act 1996. He has also been part of the high-powered Committee for Institutionalization of Arbitration in India. He is member of SIAC, Court of Arbitration, and also ICC Commission of Arbitration and ADR. He is a fellow of the Chartered Institute of Arbitrators, London, and director of CIAB, India. He is a member of Governing Council of Indian Law Society, apart from being the vice chairman for the Society of Construction Law in India and director of the Indian Arbitration Forum. He is ranked in Band 2 for arbitration by Chamber and Partners and recognized as a distinguished lawyer in dispute resolution by Asia Law Profiles. Who's Who Legal Arbitration lists him as a global leader. Benchmark Litigation recognizes him as a dispute resolution star, and Legal 500 lists him as a leading individual in arbitration. A very warm welcome to you, Mr. Tejas. Mr. Ajay Bhargava is a partner in the Dispute Resolution Group in the New Delhi office. He specializes in civil, criminal, and corporate litigation with 25 years of experience. Mr. Ajay's fora of practice includes Supreme Court, High Courts, arbitration, international and domestic, quasi-judicial tribunals, National Company Law Tribunal, National Company Law Appellate Tribunal, and National Green Tribunal. He advises in constitutional matters, civil and criminal matters, IPR laws, employment laws, and on corporate commercial disputes. He also advises on matters before the police investigation wings relating to corporate criminal investigation and quasi-criminal prosecutions. Mr. Ajay is often consulted on M&A transactions to provide tactical and advisory support. He advises on preventive measures in commercial contracts. Welcome, Mr. Bhargava. Dr. Shashwat Bajpai is the founder partner of DRSB Law Chambers and has completed his master's degree, BCL, from the University of Oxford, UK. He also holds a PhD degree from the National Law University, Delhi. He is a MCIR and an accredited member of the CIR UK, Chartered Institutes of Arbitrators, UK. He has been part of several arbitrations and litigations and argues regularly before the arbitral tribunals and Delhi High Court on disputes pertaining to the EPC construction issues. He is on the panel of PSUs and several oil and gas companies and construction companies, representing them in their claims before the courts and in arbitration. The session will be concluded by Mr. Adarsh Kumar, who is a partner with Pro Ultimus Consulting, who will also provide the concluding remarks on this session. I now hand over the floor to Dr. Shashwat, who would be moderating the session today. Thank you.
Thank you, Vanna. I think Mr. Ajay Varghwa is still not visible. So I am just trying to connect him. Is there any technical issue or some last minute exigency has come? I am not sure. But
Others, he's already on the panel.
Yeah,
he's
but
on
the
panel.
video is not visible. He is in panel. Yes, name is visible, but his video is not coming and audio is also not coming. Ajay, are you able to hear us? Ajay, are you there?
Good afternoon. Good afternoon.
Oh, okay,
Hi.
great. Fine. Yes, sir. Now go ahead. All panelists are visible and audible also.
Excellent. So warm welcome and good afternoon to all who have gathered here from their respective virtual rooms. That's become the norm now. I must start by thanking CII, Pro Ultimus, ICC and MCIA for giving all of us this opportunity to share this virtual dais with this esteemed panel. Thanks to Vandana with the introductions done, let me straight away dive into the topic of the day. Unlawful termination and encashment of bank guarantees. The legitimacy of invocation of bank guarantees has always been a bone of contention between the parties who have entered into the construction contracts more often than not with the public sector undertaking and the government instrumentalities on one side of the bargain. Now, while the general view of the courts in India has been circumspect to the extent that invocation of a bank guarantee should generally not be interfered by the courts when challenged, as it will defeat the purpose of the guarantees in construction contracts and commercial contracts. However, that being said, there are a plethora of judicial pronouncements against the invocation of bank guarantees, but of course, in exceptional circumstances. Now, we have a lot of ground to cover for the same. So without further ado, let me straight away dive into this discussion. If I could begin with Mr. Chandiok, sir. Sir, to kickstart the discussion, could you explain the difference between an unconditional bank guarantee and a performance bank guarantee and any differing threshold conditions that be required for granting injunctions against the encashment?
Thank you, Mr. Vajpayee. I must start by thanking God that I am on this eminent panel with sharing the dais with people who are eminent in this field. And I don't think I can hardly add to that, but for the purpose of your answering your query, and for the purpose of the debate, I want to go forward to say that in India, we followed the British examples of the bank guarantee and started saying we will not encash the guarantee or will not pass an interim order unless there is a fraud, and that fraud should also be so engraved into it that it's virtually brings the agreement to an end. We brought some changes after that by saying there are special equities with respect to encashment of the guarantee. By and large, because the pro forma of the bank guarantee, we all know, is normally provided by the employer, and all words possible that can be done to say bank will unconditionally pay on a demand being made. Therefore, that unconditional bank guarantee comes in. But there are instances where it has said that if there is a default in terms of the agreement, and in writing, the intimation is sent, as we saw in the first session, a question of notice came in to say that you have put the person to notice. It was a curable defect, still notwithstanding that he has not done it. Therefore, the encashment must follow. But the fact remains is the words of the bank guarantee would always be important. There is no dispute on that part. I don't intend to get into that controversy. Therefore, if the contract has to subsist, and we saw in the first session, we saw Justice Sikri telling us, Justice Deepak Mishra telling us those 6 principles, then should we not write our contracts in a way that a bank guarantee, which is really speaking the performance, is a security. You must get secured by a bank guarantee. Unlike bank guarantee, which is for advance payment guarantee. Now, and when I start a project, obviously I'll be paid some money, and for that matter, I've given the security for the purpose of repayment of that amount. Now, the words of that guarantee would be distinct from a performance guarantee. Performance guarantee would ultimately, to my mind, must follow the event. That is, unless we find there are so gross, there are times when contractors have not even started the work. Now, that's an extreme position that obviously in the construction part, if he's not even started it, then obviously there can't be any two grounds for not encashing the guarantee. But I think time has come, especially looking at the pandemic, COVID, the new clauses of force majeure that we are looking at, whether in such cases, and I beg to put this place, and I'm thinking all these people who are with me and according to yourself would even guide the participants. If the first part of the bank guarantee says, in consideration of a contract number so and so being given to the person on whose behalf the bank guarantee is given. Therefore, the contract by reference is incorporated in the bank guarantee. There's no doubt about it. In any bank guarantee, this will be the first recital that you begin with. Now, if the contract is incorporated, then should the terms of that contract not, the bank has notice of that contract. He's bound to have notice. Otherwise, how does he give it? So how do we bring all those concepts, and why do we overlook 126 of the Contract Act? Therefore, there is no written contract act in United States, in UK. Consequently, all that principles of Harbottle that we brought in here can't be a situation to my mind. We need to relook at it. However, there's no doubt about it that looking at the commercial sense of everything, we need to be circumvent ourselves. We need to be preventive to see that bank guarantees don't get stayed by asking. In fact, a very good example of this, I think my friends, all of you would look at it, that the statute in the Commercial Code Act says you have to go mandatory for a mediation. But then a section comes in to say, unless you're seeking an urgent relief. And what do we normally do, all of us? We just file an application and say, I need a stay on something, and of course even. And therefore you circumvent that provision. Therefore, time has come that the court must look at what was the purpose and intent, especially in commercial matters, to see why, if this bank guarantee is a performance guarantee, as you pointed out, it's a security for performance. And if performance itself is a dispute, as we just saw, there's an essential, Adarsh pointed out, there could be some excuses that can be done, there's some excuses that are willful. So many aspects of the contract have been dealt with in the first session. Now, if all that is correct and all that requires adjudication, then I can understand bank guarantee must remain there. It must be renewed. It must be kept alive for the purpose of ultimately getting it. But to ask the person to pay, he's already in distress. So look at a contractor who actually wants to perform. But circumstances beyond his control have done it, whether he was not given the site, whether he was not given the designs, whether he was not given ABC. So that has resulted in delay. And all the more if the employer is not making payment, notwithstanding that his running bills have already been certified by the architect or by the person, employer or the engineer, then should that bank guarantee be allowed to be in cash? Because the words of the bank guarantee are unconditional. To my mind, that is where the word special equities need to be broadened, as we broadened Article 21 of the Constitution to say that in every case, special equities must depend upon the facts of that present case. Therefore, a conditional bank guarantee certainly would be where I have also agreed that unless you make a demand in terms of the bank guarantee would not be in cash. But that I think is temporary, because the moment I do that and I probably go to court and take an injunction, it's not in cash. Next morning, the new invocation will come in terms of that, and still the situation will remain the same. However, as I said, there is time that the court must look at bank guarantee also an integral part of the construction contract, or any contract for that matter, and see if there's a case made out for special equities, and should it not maintain the subject matter of arbitration. I think the most important part is that in every situation, we forget that Order 39 doesn't talk of an application. Order 39 says in a suit, the plaintiff is able to bring out a case. Therefore, why would that principle not apply to Section 9, where you are coming to, or you even for that matter, any bank guarantee suit, where if there is actually a debatable point within the contractor and the employer, which would certainly require the attention of the arbitral tribunal, which falls within its jurisdiction, then in that eventuality, the contractor must be asked to continue the bank guarantee, keep it alive for the time, even if it is an interim award, till that time that actually some adjudication takes place. In fact, Ratan Singh and Gaurav said in the last session, there must be some evidence. No, some evidence means what? The court, if it was to examine that some evidence at the stage when you are filing Section 9 or a bank guarantee injunction, would actually prejudice the arbitration. Therefore, it must refrain itself, satisfy its conscience that there's a case made out for grant of an injunction. I don't think those principles of fraud, irretrievable injustice, all that would come in. We must change our commercial sense to say, is it commercially impossible for the person who is given the bank guarantee to perform? If there is some kind of, he has some excuse, as some expression to use, excusable delays. If that is the situation, then I think a special equity must be made out, or at least some principle must be now involved today in this commercial sense. Now we find so many clauses of, with respect to what we saw, force majeure. Now, force majeure in one case and the second case, and I said that in the opening statement, its time has come when we all need to see, when we are drafting our agreements, when all to see, when we are actually issuing the tender, to see what should be enclosed into it. Because that template from, normally I would look at Ajay Bhargav or probably Tajaria Saab to say, all right, you have done this, I will copy it and just cut, paste and give it. Time has come, we need to apply our, because that application of mind will take us better to serve the community to whom we are bound. And I think as lawyers, as practicing advocates, as practicing practitioners in arbitration, we all need to show one thing, and that one thing is we owe something back to the society. And if that is to avoid conflicts, to bring solution to the problems, then we need to start from the beginning, and that is the beginning of how do we give our RFQs or how do we make our contracts. Thank you.
Thank you, sir. Thank you so much. I think that's an excellent exposition of what the law is and should be. Now, we're all well aware that the grounds, some of which Mr. Chandiok has elaborated, have been construed quite narrowly by the courts on umpteenth occasion, and several judgments are on record to show that. Now, in light of there being no specific definition, and I take this to Mr. Ajay Bhargav, Ajay, in light of there being no specific definition qua these grounds for granting the injunction against encashment of a BG, can you share some practical examples which you've experienced before the courts, pertaining to the irreparable harm to the party, irretrievable justice, any special equities existing, and fraud, etc. All these grounds, you must have had several examples. Could you share some of these examples and anecdotes for us?
Yeah, absolutely. So first of all, thank you so much for inviting me here. And after hearing Uncle speak about what the way it should be, I'm slightly embarrassed to say that most of the times we rush to court seeking invocation of against invocation of bank guarantees. So my due apologies for doing so, but that is the mandate of our clients. So the way the system in this country is that yes, that people do give bank related guarantees. They do assure that we will do that we will fulfill our obligations. If we do not do that, you can invoke and encash the bank guarantee given by me. But the fact of the case is, in spite of giving bank guarantees, people do go in for a stay of invocation stroke encashment, because there are certain exceptions that have been carved out by our courts in the system, which permit a party to go in for a stay of invocation oblique encashment of a bank guarantee. So coming to some practical examples, in the past, we have seen one classic example is when a contract is executed and A gives an advance to B, and B is giving an advance bank guarantee to A. The issue which has happened in our experience is that the advance has either been adjusted in the bills, invoices towards the work that has been done, or simply where the contract hasn't really worked out, the advance has been repaid back to the entity which gave the advance in the first place. And in spite of that, parties are holding on to those advance bank guarantees, which are called ABGs, and not giving it back. So in such cases, we have gone to court and said that, look, we have got an advance, we've given an ABG, the work is done, billing is done, yet the ABG is not coming back to us. So that is one classic case where we have got stay of invocation of such advance bank related guarantees from courts. That is one example on what we bring within the realm of saying fraud. The other classic examples where we have achieved some orders from courts practically are where the final acceptance has been given by the contractor to us as a party who has to fulfill their obligations. In spite of that, there is a threat or a action to invoke a bank guarantee on a point that you have not fulfilled all your obligations. Again, there we have gone to court and we have got a stay of invocation stroke encashment of the bank guarantees from the court by alleging a fraud, which is namely that we have complied with everything. We have got things which are in the common commercial contracts called FACs, final acceptance, confirmation, certificates and all, yet the bank guarantees are getting invoked. So this is practical example number 2. Practical example 3, we have seen instances where the bank guarantee is being sought to be invoked by an entity which itself is likely to go into insolvency. There we have gone to court and say that if a bank guarantee of a large amount is allowed to be invoked and encashed, and tomorrow in the arbitration I get an award in my favor, how will I ever get this money back? Because the other side will go insolvent or already is insolvent. So I will have no legal this thing available remedy available to get back my amount. So these are a few of the examples where we have practically gone to court and we have been able to convince the judges to give us a stay of invocation stroke encashment of a bank guarantee. So that's it from my side on the practicality of the recent past. And I can say since last year, the other additional aspect has been on FM clauses and COVID. So we have also got some orders from the courts saying that because of COVID, because of pandemic era, because of FM clauses, bank guarantee should not be invoked or encashed. Thank you.
Thank you, Ajay. Thanks a ton for that. I'll direct this next one to Mr. Tejas Karia, and I'll start from where, in fact, Ajay left at the end. With this huge furor surrounding the COVID-related force majeure consequences for the construction contracts, especially those are at the fag end of their contract terms. A question that has been doing the round, there are judgments to that effect as well. Mr. Karia, can you tell us that can force majeure apply against encashment of bank guarantees? And can you shed some light on the views of the High Courts? As Ajay also mentioned, the Delhi High Court has taken a view in Halliburton, Bombay High Court has taken a view in Standard Retail, if I stand corrected. Now, several other recent cases. So could you shed some light on that, please?
Thank you, Shashwat, and good afternoon, all of you. I'm really lucky to have this last minute entry to this and sharing the panel with such an esteemed experts on the subject. Coming to the question which Shashwat asked, and yes, this has been a great challenge over a period of time, and especially in last 1.5 years since we have been facing with this COVID situation, is that the people who really want to perform the contract are prevented from performing because of the circumstances beyond their control. And they've already given the bank guarantees for their performance or for any other reasons why they are liable to perform. And in strict sense of the contract, the other side is entitled to invoke the bank guarantee because there is no performance. Now the dispute arises whether your performance is barred because of the force majeure, and that depends on the terms of the contract, and the courts are bound to interpret the terms of the contract. as Mr. Chandyok rightly pointed out, that you cannot have cut and paste job on the contract. The force majeure clause has to be interpreted and drafted properly at the time of entering the contract itself. But in many cases, which we just realized over the last 1 year, is that the pandemic was not mentioned, or any such kind of situation was not mentioned. Of course, we apply the concept of ad justem generis, where you have the clauses prior to then. If you say any other such circumstances or similar events, we have been trying to explain this to the court and the arbitral tribunals. But well drafted and clear force majeure clause makes a lot of difference when it comes to getting injunction is concerned, because at that stage the courts are only looking at the prima facie case, balance of convenience and irreparable harm. Now, the other things which we have also tried is frustration of the contract. When you have a force majeure, the frustration cannot come into effect because the contract continues and the contract is suspended during the period of force majeure. Now, bank guarantee is a separate contract, and that is where even the arbitrators don't have power to grant interim relief, because bank is normally not a party to the arbitration agreement under the underlying contract. So we have to go under section 9 if you have an arbitration clause or in a suit against the bank for against encashment of the bank guarantees. And when these issues came up in the light of COVID situation, the court had to really examine the facts of each case and come to the conclusion. For example, in Halliburton, though initially there was an injunction, but in the final order, the court vacated the injunction, saying that, look, ultimately this contract was breached much prior to COVID. And if the situation arose much prior to COVID, the force majeure clause will not come to the rescue for invocation of the bank guarantee. And therefore, the bank guarantee was allowed to be encashed. Similarly, in Bombay High Court, in standard retail also, the same issue came up, is that whether the contract was frustrated. If the underlying contract was frustrated or not, but the bank guarantee being an independent contract between the bank, the issuer and the contracting parties, has to be seen independently, unless those two exceptions, which Mr. Chandyok again pointed out, is egregious fraud and irreparable harm, is proved, and that also has to go to the root of the question of the performance of the contract. And therefore, this force majeure in terms of performance, the suspension of the performance and the bank guarantee go hand in hand, but it has to be seen differently. So the courts have applied that principle of bank guarantee being an independent contract. They see the force majeure clause under the contract and see if that contract itself is not frustrated or it continues, then the bank guarantee can be encashed and you cannot get injunction against the bank guarantee. But it really depends on the facts of each case. In many cases, the courts have not stayed the invocation of bank guarantee. In some cases, the courts have, depending on the facts of the case. But the principle remains the same. The bank guarantee has to be strictly interpreted, and courts are quite reluctant in granting injunction against invocation of bank guarantees. And that is where the challenge comes, is that how well your contract is drafted and what are your facts of the case. If the facts of the case is that the force majeure continues and still you want to invoke the bank guarantee, then it would be a fraud, because that is somewhere we can at least argue before the court, or that you cannot invoke the bank guarantees while the main contract is suspending the performance due to the force majeure clause. But if it is not well drafted clause, then we have a big trouble, and we have seen both Bombay High Court and Delhi High Court recently in last 1 year has refused to stay the invocation of bank guarantee. And the banks are also under tremendous pressure, because what happens is that if they don't perform under the contract, they are made liable, and there is a breach under the separate contract, which is a bank guarantee contract, and therefore bank do mechanical thing, and that's where I really like Mr. Chandyok's views, is that we have to really see that the justice is done, and we can't be just mechanically invoking the bank guarantee and putting a party under more distress. Whether the party is not performing, there must be some reason for not performance, and we are just making the contract completely unviable in a long-term basis, because we have to also be seeing that the parties has always an intention to perform. It is just that because of situation beyond their control, they have not been able to perform. And that's where the mediation has helped a lot, because what we have seen is that sometimes the contractors and the owners have taken a reasonable approach, try to mediate, and instead of invoking bank guarantees, they have given more time, changed the terms of the contract, entered into an innovation, but rather than just completely frustrating the contract by invoking the bank guarantee. We have to keep it in mind that the invocation of bank guarantee is a drastic step, because what you are doing is actually today the banks are not giving bank guarantees unless you put 100% deposit or give a very valuable security to them. And any which way, there are issues with the subcontractors, there are issues with the employees. They have to keep going, and this is the very difficult time for everybody. So we as a court and an ecosystem and the arbitral tribunals and all have to ensure that if in the case is correct and the facts are there, we should grant injunction against invocation of bank guarantee rather than just allowing the banks to do it. Because if there is no injunction from the court, bank has to pay. The bank has no option, because all this, mostly the bank guarantees are unconditional, and therefore bank has very little discretion to apply their mind to stop invocation, because they need a court order. And that is where the reaching out to the court very quickly and getting the injunction is quite important. But the courts are also tied, because there is jurisprudence which says that you will not restrain the invocation of bank guarantee unless in a limited circumstances. So the court has to play a very, very balancing act, and we have seen many of such cases where the courts have gone into the facts and come to the right conclusion. And hopefully we will see that continuing. Anyways, the pandemic is hopefully doesn't come back, and we get back to the normal situations. So all these issues cannot come in our way of performance. But we have seen a huge amount of litigation, and I'm doing a couple of arbitrations just on this point. And if we think of it, this issue is a non-issue basically, and it's just that the parties are taking hard stand and trying to be unreasonable. But that's their prerogative, and we have to defend, as Ajay says, these are all the client's instructions, and we have to perform our duties. So that said, the bank guarantees is a very interesting topic, and it comes up and it goes both ways. So when we go into the court, we don't realize whether we will get it or not, because it's always a gamble to get a stay against invocation of bank guarantee.
Extremely insightful, Mr. Karia. Thanks a lot. And I think I'll agree with I think Halliburton is an excellent decision, because what it did by distinguishing the pre-COVID delay and the post-COVID delay, it has given a judgment to the extent that COVID, just by saying COVID force majeure, it cannot be a panacea to all the, getting the interim relief in those cases. Now, I'll take this to Ajay. Ajay, all of us are well aware that Section 9 has been one of the most invoked sections on the statute book, along with Section 11 and 34 of the Act. If I could come back to you to discuss few exceptional cases and circumstances where courts have actually allowed the injunctions to restrain invocation of bank guarantees by applying Section 9(3), where in light of the inefficacy of such relief before the arbitral tribunal under Section 17. If you could throw some light on that, please.
This is a very interesting one. As we all know, after the amendment to the Act, we are all shown the door by the High Court that once the tribunal is constituted, why are you here? And that is rightly so. In the interest of the two warring parties, it's always good that their dispute remains in the confines of the arbitration only, where there's an arbitration clause, and let the arbitrator take care of all their matters. That is the thumb rule, which I also agree with, believe in. Now, 9(3) as an exception is where recently our Delhi High Court in Blue Post held that where 9(3) comes into play, even though there is a tribunal, is where you want orders against third parties. And because third parties are not before the arbitrator, so arbitrator cannot pass orders against them. There is no contract in between those third parties and the two warring parties. So therefore 9(3) comes into play, that there is no efficacious remedy left to go to the tribunal, hence you come to High Court. And in my experience, I have seen I've got only one order under 9(3) so far. Rest I have been relegated to the tribunal. So I'm a very bad example for remedy under 9(3) in my experience, and I say this with the greatest humility around this panel, that maybe my eminent panelists have been more successful than me on getting orders under 9(3). In fact, I lost one last week only. Yeah, so that's it from my side.
Okay. Thanks a lot, Ajay. Thanks a lot. In fact, you having raised that issue, that one of the few rare cases where you actually got this training order, anecdote comes to my instance comes to mind. I was arguing on behalf of a construction company before the Bombay High Court in a Section 9 injunction encashment of a BG. Now there the issue was where a performance bank guarantee from one contract was being encashed to recover dues under another contract between the same parties, one of them being the PSU. The court, of course, followed the decision in Gangotri 2016 Supreme Court and granted me relief. Chandyok sir, if I could get your views on this, can a performance bank guarantee from one contract be encashed to recover dues from another contract between the same parties? Have you had
Well,
any occasion to deal with such a case, sir?
I think the Bombay High Court is absolutely right. If the bank guarantee is a contract by a bank under a particular contract, how do we encash it for a default in another contract? That can't be. In fact, if you remember earlier, the law, we got into it that if I have money in my hand, I'm not able to appropriate it towards something else, some other contract, I can withhold it. So withholding is one thing. Now, withholding is with the bank in a bank guarantee case. It can't be with the person that you will encash the guarantee of some other contract. So I don't think there can be any possible view contrary to that. But adding to what Ajay was saying, I wanted to consider a question and I want to put it to my eminent, all of you. Is there an ouster clause in section 9(3)? Is the jurisdiction of the arbitral court ousted when the tribunal is constituted? To my mind, no. I thought the departure is made by the legislature that court's jurisdiction is not ousted. Therefore, in a given circumstances, notwithstanding that I have a arbitration pending, the arbitral tribunal is constituted, the jurisdiction of the court is not taken away. At least what Ajay says, and I think the experience is this: normally when you go and you say arbitral tribunal is in place, court says, please, we'll convert this into 17, you go and urge before that. But we don't apply that. That's the suggestion that I'm making. Time has come with, I agree that if 60 is my strength in Delhi High Court and if 30 or 31 are working, obviously there's a problem there. And there's a problem everywhere today. And I don't think I've seen appointments coming through in the last few years, which we need to look at. And the entire system is collapsing into that matter, because unless you fill up the vacancies, you know when a particular tax is going to retire. Why don't you fill it up beforehand? The Supreme Court said so, but it is not ready to take up the cudgels now today. That's the whole problem. Otherwise, probably the Supreme Court should have called upon the government outside without even Ajay or me or you, anyone of them going to court. In fact, it is so sad to see that on 27th of November, the court was told, I will fill up all vacancies in the NCLT within 2 months. 2 months have gone by, we are in July. Not a single move has been made. Now, therefore, we are crumbling the system. And that is one of the reasons why the court is not looking at it even in 9(3). To say that I have jurisdiction, I can't. And I think with all sense of humility, I must say, a court cannot delegate its own jurisdiction even to the arbitral tribunal. It has jurisdiction. It may pass or not pass an order in the facts of the case. It's a different question. On the merits, you may pass or not, but simply by saying, please go and apply to the arbitral tribunal, to my mind, is not correct. Because 9(3) is not an ouster clause. 9(3) is the other way around. It says, notwithstanding that position, really, to add those words into the statute, is the High Court or the commercial court or wherever that court is will always have the jurisdiction. And I think time has come when some of us will have to urge this, even for the sake of debate, take it to a higher court and probably need this to be ironed out. To me, the intent of the legislature is absolutely clear, subject to what you all feel. But having said that, court can never be out of it, because if 42 has to apply, that court has to come in. If 34 has to come, the same court has to come in. Then how can a court say, especially as Ajay rightly pointed out, there are third parties involved. And your case, for example, in Bombay High Court, when somebody else is doing fraudulent action, which we call, and I think I missed the point, fraud is defined in the Contract Act. How do we go to that fraud which goes to the root of the matter. I had no intent at the time when I entered into the contract to perform. Is the fraud. I made a statement which is contrary to what I actually know the truth. That is fraud. Then how will all those things, which court has considered that? Except I think one place I saw Justice Mahinder Nayan looking into this question in one of these judgments in Delhi High Court. But that judgment was taken in by that time, probably the matter got settled or resolved. Therefore, an SGC matter. But what I'm requesting is the time has come when the court should be, if there's less burden, obviously the court will examine those issues. If there's less burden, court will look at it. Now look at a small problem in your arbitration. There's a schedule provided, 30 lakhs. Okay. Whether 30 lakhs would only come for the entire or there's a counterclaim which is made, then what happens? Would it be assessed separately? So whereas fourth schedule is concerned, is silent. But nobody looks at 38, nobody looks at 31, which says the arbitral tribunal can call upon me to pay an advance for a counterclaim separately. And first principle of interpretation on the contracts or the statute is that a schedule must give way to the statutory provision. But the problem is, where is that time for me to urge the court to consider? And I think that's where I'm raising a larger issue for us to see that we need to bring cases to court where we need these substantial questions to be considered. It's time that the court must, because many times it is said, oh my God, this has taken so long. But please understand, if those 12 cases, for example, of insolvency, had not gone to court and not gone up to the Supreme Court, there'll be thousands and thousands of cases still pending. So many clarifications have been given by the court today in IBC, which has resulted in today the progress making. So timelines are fine. I agree. We must be cost effective. We must be speedy. We must do everything, but not at the cost of justice, because justice is incorporated in my constitution and I can't break.
Very well put, sir. Very well put. I think probably I would have to agree with your interpretation with respect to Section 9 of Clause 3, whether courts can actually exercise their jurisdiction similar to that of a writ court. In the sense that when you go to a writ court, you always have to show that there is no alternate efficacious remedy. If the same can be taken up in 9.3, we'll be in a much better position. I'm thankful that so as fascinating as it is, to be in this new era of refined arbitration act, thanks to the mega 2015 amendments that have been brought in by the legislature. Now, all of us will agree to one fact that one of the most progressive clauses inserted in the act is the proviso to subsection 2 of section 2 of the act. And if I may take this question to Mr. Karya, sir, in light of this insertion, what is the scope of section 9 invocation against the encashment of a BG in case of an international commercial arbitration? Sir.
So the whole purpose of bringing this 2015 amendment was there, and I was part of that discussion while I was assisting Law Commission on that, is to create these three regimes. Like we had this Bhatia regime, Balco regime, and then we had to come out of that because international commercial arbitration having seat outside India, the part 1 was declared to be not applicable by Balco, and we had to come out of it. And the whole idea was that if the subject matter of the arbitration is in India, Indian court should exercise the jurisdiction. It cannot deny the jurisdiction to protect the subject matter just merely because the seat of arbitration is outside India. And that's why this proviso was added to include section 9 for international commercial having seat outside India. And section 9 should also be available to parties who want to get a stay against invocation of bank guarantees, because just because you have a seat outside India and you have one party is a non-Indian, you can't just have to go to Singapore court or the court of the seat or go to the emergency arbitrator where it may not be efficacious for us to have the interim relief against the bank. With emergency arbitrator or a court in Singapore cannot exercise the jurisdiction against Indian bank to give injunction against the invocation of bank guarantee. And the invocation of the bank guarantee is the most quickest relief we need from the court, because by the time the tribunal is constituted or emergency arbitrator is appointed, you may end up in a situation where the entire relief becomes infructuous because the bank would have made the payment. So therefore, Section 9 was a very important tool which was to be kept alive. And unfortunately, because of Balco, we didn't have it, and we had to amend the Section 2.2 proviso. And now we have this. Now the question came up is that when two Indian parties select the seat outside India, can they have the same
That's
relief
right.
available? Because just because they two Indian parties, governing law has to be Indian, just the seat is outside India, can you be deprived out of the jurisdiction of Indian court? Because if that is the case, then it's very easy that I become remediless by just selecting the seat outside India. And that was always a confusion, but fortunately, recently the Supreme Court in PASL Wind Solutions versus GE Power has clarified this and disagreed with Gujarat High Court's view on this, and said that even though you go outside India, just because the word international commercial arbitration is used in proviso to Section 2.2, that doesn't mean that the parties would not have a benefit of Section 9. And especially when it is a question of bank guarantee invocation, that right is invaluable because you have to literally get an injunction within 24 hours or max to max 48 hours. And if you don't have that benefit of going to Section 9 court, then it becomes very difficult for parties to protect their rights in the subject matter of arbitration. So this judgment especially clarifies a lot of open-ended issues where you can get relief under Section 9 in a domestic arbitration because it's between two Indian parties having seat outside India, and international commercial arbitration having seat outside India. Of course, if it is international commercial arbitration and the seat is India, then Section 9 would apply in any case. So there is no question about that. But it's only the question was with when the seat is agreed by the parties to be outside India, what would be the situation? And now, fortunately, we have just yesterday the judgment on Amazon versus Future, where also the emergency arbitrators orders are now enforced under Section 17. And that's the great achievement we have got now. At least we tried twice in 2015 and 2019, and both I was involved in the changing of the definition of the arbitral tribunal. We failed to include the definition of emergency arbitrator into the definition of arbitral tribunal, because it was very easy fix. And we tried two times, Justice A.P. Shah's recommendation and Justice Sri Krishna's recommendation, both had this particular clause, and somehow we had to wait for this judgment to now have the clarity with regard to that. So even if emergency arbitrator has granted stay against invocation of bank guarantee, that would now be enforced in India as if it's an order passed under Section 17, provided the seat of arbitration is India and also even if it is an international commercial arbitration. So fortunately, we have a lot of clarity post 2015 with the judgment of PASL and Amazon yesterday. So with that, I feel very confident that India would have some kind of a parity with other jurisdictions who also protect the subject matter of arbitration. And the courts are the custodian, or they have to support the whole arbitration process by at least intervening at the early stage of granting interim measures, because if the interim measure is not granted or taken by parties at the right time, then the whole process of arbitration is just an academic exercise. So we need to be very, very conscious of approaching the court and getting the relief if we are entitled to, of course, under the law and the facts. But the strategy on getting interim relief is very important, irrespective whether it is domestic or international arbitration or Indian seated or foreign seated arbitration. So that way, I feel that now we are in a very, very good position as compared to other jurisdictions, and we are at par to the other jurisdictions like Singapore grants it, London, UK based courts are granting it. So there was only one criticism which we have come over either by amendment or by the judicial pronouncement. So that way we have achieved a lot in last 6 years.
Thank you, sir. I was about to say you may even touch upon the emergency arbitration, and you've already done that in the answer. That's excellent. Well, it's been a fascinating discussion. We've heard some stimulating thoughts pertaining to the issues at hand. I now open the floor to any audience questions. Please feel free to unmute yourself, but I request that please no singing similar to the Juhi Chawla hearing before the Delhi High Court. So, any audience questions, please?
Sorry, Saswat, are you able to see the chat box where some questions are in the chat box?
Sure, sure. Give me a moment here.
You can pick up one or two questions because we are we are running behind the schedule, paucity of time.
Very well. I'll take one. I'll take one quickly. Yeah. So this is what would be the consequences of refusal of the court or tribunal to injunct the encashment of a BG at the interim stage in case where eventually the court or tribunal holds it to an unlawful termination? That's an interesting question. I'll open it to the panel. Anyone can take that, please.
No, it's a simple situation. If it is ultimately held to be unlawful, obviously the bank guarantee amount would also be a claim in the arbitration and would have to be made good by the other side. There's no dispute with that one.
There is another one. Just one
because
second.
Many times, just to add to
Sorry,
that, many
please.
times we amend the claim because what happens is the bank guarantee gets invoked, and then ultimately you win. Then that would be an additional claim which you and normally the tribunals grant that kind of amendment to the claim because that is a subsequent development which was not there at the stage of filing of the original statement of claim.
Others, shall I take one more or shall we call it a day?
You can take one more questions.
Okay. It's a small one. Can a bank guarantee be encashed if and where the contract has not concluded or terminated? Again, it's open to the panelists. Anyone may answer, please.
That would be on the terms of the contract itself. So if the contract says that in the event of non-fulfillment of obligations, the bank guarantee can be invoked, it can be invoked.
Very well, very well. Well, it's been a fascinating discussion, as I said, and I thank each and every panelist. I'll give it to Adarsh to the formalities. Thank you and good day to everyone.
Thank you, everyone. Thank you, Mr. Saswat. Thank you, Mr. Ajay, Chandyok sir, and Mr. Tejas. It was a very insightful sessions, and our viewers, I'm sure that viewers got an extreme advantage being all eminent panelists at one forum, and it was really, really interesting sessions and very insightful sessions. Thank you, all of you, and then we'll move to the session number 3. Which is also very interesting, which is a COVID-related issues, and a lot of queries we used to get from our client, especially from the contractor, which is I would say nowadays it is a very, very hottest topic. So this is the session 3. So I would request all participants also to join session 3 as well, which will start immediately after 5 minutes break.
Thank you, Adarsh. Thank you for the opportunity.
Thank you, everybody.
Thank you, Adarsh. Thanks a lot.
Thank you,
Thank
Amarjit
you
Uncle.
so
Thank
much
you,
for
Tejas.
conducting it so well.
Thank you, sir. Thanks a lot. Appreciate it. Thank you.
Thanks everyone.
Thank you.
Yes.
Bye-bye.
Yeah, we will take a 5 minutes break and then session 3 will be start immediately.
Yeah, Adarsh. Hello.
Your Mr. Venkat Ramana video is not coming.
Yeah, there is some problem. I'm trying to switch it on.
Testing.
No, still your video is not coming, sir. Vijayan is visible, Nagesh is visible, Vandana is visible.
Okay, I will leave the meeting and join again.
Yeah, okay, you rejoin.
Adarsh, I would like to see whether you could hear me.
Yes, loud and clear.
Fantastic.
Much better. Vijayan, in the meantime, you can also check your mic.
Sure. Am I audible?
Yes.
Testing.
Yes, loud and clear. Why?
All right, great.
Perfect. Let Mr. Ramana join then.
I can speak. You can take me on audio. Okay. Can you hear me, Adarsh? You're on mute.
Adarsh, I think you're on mute.
Sorry. Mr. Ramana, your voice is coming, but your video is not coming.
Okay, that's okay. I would prefer to join by audio then. Okay, because I don't want to waste my co-panelists' time and time of others. So we can start. I can start with the audio.
I think the jinx is continuing for the session 3. Earlier, Dr. Vandana, what was supposed to be the panel, one of the panelists, he is a very renowned icon, so iconic face. So due to some personal exigencies, she could not join. And suddenly, yesterday night only, I got Montek, who is also a very renowned quantum expert. He also could not join because of his personal exigency. And now Venkat Ramana on video is not coming anyway. And this session was to be moderated by Atika. So Atika, because of this session is running 30 minutes behind the schedule, and Atika will join very soon. In the meantime, my colleague Vandana will introduce all the panelists, and till the time Atika doesn't come, Vandana may take up some questions. So Vandana, over to you. You can introduce the esteemed panelist.
Yeah, good afternoon to you once again. Now we are in session 3, and I take the pleasure again to introduce the esteemed panel members and the speakers for today's session. I introduce Mr. Venkata Raman, who is Head of Contracts and Legal Department of Tata Projects Limited. He has close to 3 decades of rich and diverse experience in legal matters involving environmental laws, construction contracts, trademarks and copyright laws, industrial laws, company law and arbitration laws, and public interest litigations. Prior to joining Tata Projects, he worked with Hindustan Construction Company, where he was heading the legal department for 11 years. And before that, he was associated with Ambuja Cements Limited. He practiced with the High Court at Hyderabad. Mr. Ramana is a law graduate from Osmania University. Our second panelist is Mr. Zhang Ang. He is a partner with Fenris Mr. Vijang is an international disputes lawyer specializing in construction-related international arbitration and litigation. His majors arise from the major and high infrastructure projects across Asia, Africa, and CIS region. These include railways, water desalination plants, wind farms, highways, power stations, process plants, high-rise office buildings, and hospitality projects. He acts on foreign law governed and internationally seated ICC, SIAC, and ad hoc arbitrations and dispute board proceedings. He advises on a range of complex construction issues regarding FIDIC provisions, time and cost claims, fitness for purpose, design and build obligations, ground conditions, force majeure, performance bonds, and termination, etc. Mr. Virang is among the inaugural select batch of Singapore qualified lawyers recognized in 2018 as an accredited specialist in building and construction law. He sits on the Singapore Academy of Law Construction Protocol Working Group. He was previously attached to and has worked with major Magic Circle barrister chambers in London. Mr. Vijang also writes, and his articles published in the International Construction Law Review and Singapore Arbitration Journal. Our third panelist is Mr. P.M. Nagesh. He is Director of Chambers Singapore and Managing Director of Chambers India. He is a quantity surveyor with legal qualifications. He has about 30 years of experience in construction, oil and gas, and energy industries. He is a fellow of RICS, CIR, and SIR. Mr. Nagesh provides advisory and expert services in complex delay and quantum disputes. He is a qualified arbitrator and panel member of SIR and AIEC. Our fourth panelist, Mr. Montek, as others, was unable to join us today. So I just request Mr. Venkataraman to start his.
Okay. Good afternoon, everyone, and hope you are able to hear me. If you can't see me, I think that's okay. I'll try to fix my camera. I think the topic that was given to us, all the panelists, is how COVID claims has to be approached, both in terms of tenability and quantification. And I will be addressing mostly from the contractor's perspective under the Indian regime. What we have seen is that initially when the COVID broke out, there was a huge discussion whether this was actually a force majeure event or under what heads a claim can be made if there is any delay in execution of the project or there are any disruptions which lead to additional costs. Fortunately, the Ministry of Finance, sometime in February 2020, they have come up with a office memorandum, and they have said that this event would be covered under force majeure claim. But what is important is whether the claim has to be made under force majeure or any other provisions in the contract. I'm talking about generally in a contract. For force majeure, the entitlement is typically time and no costs are entitled. That is how the force majeure is typically structured in most of the standard forms of contracts. So a lot of thought went into it, and it was decided that it is better to use a change in law provision. If you see, there are a lot of circulars, orders, and notifications that have come from National Disaster Management Act. So what we said is that basically any ordinance or notifications which asked our project sites to be closed or asked our project sites to follow certain norms, this will typically be covered under change in law, and the contractor will also be entitled for costs. That's the approach generally the contractors in India have approached with regard to notification of counterclaims. I think Mr. Nagesh and Mr. Vijay can talk about how the approach is there in other jurisdictions and how these claims can be quantified.
So Vandana, you may ask questions to Mr. Vijayan and Mr. Nagesh also, so that they can answer in that way. Yes, Vandana. Your voice is not audible. Vanna, your voice is not audible.
Yes, yes, I'm audible now.
Yes.
Yes. Just a quick question, because we have seen most of the contracts, like if the contracts had started pre-COVID, there was no go, because they were already written contracts. But contracts which were written after the COVID started, most contracts now employers have been quite alert, and they have now started writing contracts in which they the contractor for claiming where such kind of claims. In such scenario, what would you suggest would be the way, contractors, under what head it is advisable that you take up these claims? It can be open to anybody who wishes to answer.
So this question is especially to Mr. Vijayan, or you have asked general questions?
Yes, it can be taken up. In fact, Mr. Venkat already spoke about these claims and how. So he could throw light on it, or Mr. Vijayan also could. Hello.
Yes.
Hi, sorry, I think I realized I was on mute, which is a typical syndrome on webinars. I thought I'd just start by saying thanks to CIA and Pro Optimus, especially Adash, for sort of coordinating and hosting this. From a legal perspective, there are sort of various ways you can slice this whenever you intend to mount a COVID claim. And the typical sort of provision you would go under is something that's been foreshadowed by earlier, which is that it usually turns out to be a force majeure claim. So Venkata is right, that is usually the starting point in which you seek, for instance, time. But as sort of Venkata also sort of alluded to, cost is usually going to be a problem. And so therefore the second way and the second provision you tend to look at immediately after force majeure, an amended version if possible, doesn't give you a cost entitlement, is to look at a change in law provision. And if you look at the change in law provision, it's fairly complicated. There are various things which are important about a change in law provision if you have to think about. And just off the top of my head, you can probably envisage sort of 3 or 4, maybe 5 criteria you need to meet if you want to make a claim. So one obviously is whether or not there is in fact a change in the law. And when I say change, it means you have to consider whether it's a change or whether it's a implementation or whether it is an enactment of a new law. Some provisions may differ from one another, and so therefore there needs to be some focus on that particular word, change. The second thing to think about is what are the laws you're talking about in question, right? Is it a directive? Is it a municipal law? Is it a legislation? Is it a statute? Is it a decree? Who must it be passed by to constitute a law? Does it need to be passed by a particular ministry within your government? So that's the second thing to think about. The third is, when exactly was this new law changed? It must be pegged to something. And the usual FIDIC form sort of envisages it to be after a particular date. It could be the commencement of the project. It could be after certain advance payments were made. So you need to look at the clauses quite carefully. So that broadly is the second type of provision you want to think about if you're pursuing time and cost. And the last one, which sometimes tends to get neglected, is perhaps a typical variations clause. And that's because it will come in the form, it as in a direction from the employer, may come in the form of a instruction by the employer to stop work because of COVID, to implement various COVID-related measures in terms of quarantine, in terms of work stoppages, in terms of restriction of working hours. And if so, if a contractor is able to view, consider, and package it as though it is a variation instruction, then that may be another avenue in which you are entitled to claim time and costs. So I guess my point is, if you step away from just the typical force majeure claim, you may have options, but you would have, I think you would have to explore these options a bit carefully with your legal team to assess the prospects of success in these provisions.
Yeah, sorry, Vandana, actually there are some technical glitches, so we are trying to fix up the CIIT team so that Mr. Venkat Ramana's videos may also come. In the meantime, you may ask questions to Mr. Nagesh also, and other questions with Mr. Vijayan. Yes, Vandana.
Yes, Mr. Nagesh, we just have a question for you. Is under construction contracts, what are the major heads of claims put forward by contractors due to this COVID pandemic? And what are the restrictions, like based on the restriction imposed by the authorities? If you could just take up that question.
Thank you, Vandana. Good afternoon, everybody. Vijayan, Ramana, Adarsh, and all the participants and attendees. This is a peculiar and unprecedented COVID situation the whole world is in, and of course, construction industry is not immune to this COVID impact. So during this COVID situation, actually, what we see is a number of claims coming out from the contractors of varying heads, I'd say. First of all, of course, it will be a delay to progress, resulting in domestic and overseas procurement delays. And of course, all these progress-related delays, which are eventually turning into completion delay. So in a nutshell, it's a delay to the project completion. That is something first the contractor will be notifying, and of course, seeking extension of time as well. This is the first head, I believe, is mostly the construction industry is facing. And second is, of course, when the delay happens, the associated costs for the delay follows through, and the contractor would either reserve their right for the additional compensation due to the delays, into the progress and completion. And the third one being the loss to productivity. So this COVID has created a situation where the resources are not fully available at all times for the construction sites because of various restrictions, lockdowns, and various parts of the country having different movement constraints. So that either resulted in the workers from the construction site moving away to their hometowns, as well as unable to return, and so on. So this has resulted in a resource crunch, and the contractors are forced to work with whatever the resources they are able to mobilize, and then creating a kind of a mix of manpower and even rather equipment and the materials with the mismatch with whatever the actual requirements of the site would be. So it results in a kind of the productivity loss. So they would not be able to achieve the intended productivity, but they will be achieving either very low productivity or none at all. So the disruption caused by COVID and the resultant lockdowns and other restrictions has caused the productivity loss, and of course the loss of productivity is something the contractors are looking at. Then, of course, during this pandemic, when the delays and disruption happens and the resources are scarce and the costs going up. So the escalation, the costs of labor, material, and equipment is the next kind of claims contractors will be looking at. And of course, when the cash flow is scarce and the project is not moving, the contractors are not receiving payments on time or as they are planned, then the financing costs for the project for the contractors goes up. Then that becomes another kind of a claim. Then comes, of course, for the work done, either before these restrictions or before the pandemic, or during these troubled times, whatever the work has been done, they need to get paid for the work done. Particularly when it's a lump sum contract scenario, the contractors won't be getting paid unless they have reached to a certain stage. So even if they have completed 90% of that particular stage, unless it is 100% complete, the employers are not willing to pay for the work done. So the contractor would be in a position that after doing some or much of the work, they would be waiting for the stage to be complete and to get paid. And of course, the next one will be the contractors will be looking for some sort of waiver of interest imposed on the contractors on the advance payments they would have received from the employers, particularly when the employers are government entities, basically. So that is something because they will be still paying interest under the contract unless the entire advance payments are returned. So this pandemic has delayed that return of advance payments, and therefore the interest charges from the employers will be mounting and snowballing and resulting in contractors looking for waiver of financing costs as well. Interest on advance payments as well. Then, of course, the last one will be the performance guarantees. As the performance guarantees would have been given for a particular contract duration plus the defects liability period and so on. But when the pandemic caused delays and disruptions and the completion is not happening, then they are asked to extend the bond to the full extent of, let's say, in case if it is a 10% of the contract value, even though the work completed is 50% of the contract value already, then still you will be asked to extend the entire performance bond. But in my understanding, the government of India has given some leeway to reduce the performance bonds to the extent that the works have been completed and so on, with some caveats in that. So that will be something the contractors will be looking at. So these are all the type of the claims and the commercial issues the contractor would be putting forward to the employer and then seeking resolution. Over to you.
Can I
Yes,
just jump
thank
in
you.
on that? Actually, I just wanted to comment on a quick point that Nagesh had astutely pointed out, and that concerns disruption costs. And as all project teams would know, a disruption cost compared to your typical time cost, a time claim, or a typical sort of prolongation type claim. A disruption claim is notoriously difficult to put together because you're not looking at very straightforward things. You're looking at a decrease in productivity because of, for instance, a change in the planned sequence of works that has arisen, which means that there may not have been actually a delay on the critical path. It is actually, something that could be encompassed within the project schedule and timeline, but for whatever reason, you may have incurred additional costs because your labor required more man hours to do the same thing compared to what was initially budgeted. And if I draw draw it in the context of COVID, that might be quite difficult to isolate, because sometimes COVID requires complete work stoppages. And so therefore you could have a complete stoppage of work throughout all parts of the project. And so therefore, the more immediate and more direct claim you would put forward is a typical time-related idling cost claim, or an extension of time claim, because that's a bit more apparent. And if you try, to put in a disruption claim, the question that may then arise is why are you sort of seeking to double count, specifically in the context of COVID? So maybe that's something that contractors and possibly employers, when receiving a claim like that, should bear in mind.
Thank you, Vijayan. Vijayan, you have brought out a very important point. If it is a complete lockdown, yes, of course, it should be an idling cost claim. But of course, the lockdowns, if they are blanket lockdowns or stop everything, then that would apply. But it happens that that in one part of the country there is a lockdown, but in another part of the country there is not. But there are movement restrictions, and your workers were about to come back to your site from that particular province or part of the country. Then you will be left with a kind of workers, without certain skill sets. But you are not technically under lockdown, so but you have to still perform the works. But in that scenario, you will be performing something to your possible extent, but the result you will be getting would be not to the extent you would usually look for. But I agree. I mean that there could be idling claims as well during this COVID situation.
So let me ask one question from Vijayan. So Mr. Vijayan, I just wanted to understand, it is mentioned that the contractor may mount a claim on the basis of change in law clauses also. What are the prospects of success of that argument from a legal perspective? You can just give a highlight from Singapore perspective. Of course, this question will be passed to the Mr. Venkat Ramana also. He will throw some light from Indian perspective. So over to you, Vijayan.
I mean, it's usually quite difficult to say what success is going to look like. So, as all wily lawyers will say, it depends, because there isn't going to be a straightforward answer. And Venkat, I see, is chuckling there. He presumably, from the contractor's perspective, would very well be familiar with that line as well. I've touched on this slightly briefly at the start of the session. I've mentioned that typically a change in law clause would find itself in a standard FIDIC form contract, for instance. It could find itself in various modified versions in other contracts. They could be bespoke ones. And so therefore, it really depends on the wording of the clause. But the typical the typical elements of a change in law clause we'll talk about, like I mentioned, a change. That's the first. The second, it would involve a ascertainment of what the laws are, what constitutes laws, and that requires you to understand what the governing law of the contract is, so that you could approach the correct legal team in a particular jurisdiction to advise on whether a particular direction, a particular statute, a particular piece of legislation constitutes laws. And that was one of the problems, well, I wouldn't say problems, but that's one of the issues we faced when we were advising on a renewable power project in Asia. And the contract was not governed by Singapore law. It wasn't governed by any law. It was governed by other countries' other countries' laws, and so therefore we had to approach and engage a specific firm to deal with that. There is also a question of the fact that the change in law must affect the contractor's progress. And sometimes that gets sort of neglected. But when I say affect, it throws into the spotlight whether it's a indirect or a direct impact on the contractor. What about knock-on effects? Would that fall under a typical change in law clause? So if I give an example, if a change in law of one country caused delays to project A, and the delays on project A cause delays to project B, can a contractor on project B say that its delay was caused by the change in law? Or would the employer say that the cause of the delay was not project B, but project A, and not therefore a change in the law per se? So there are various ways you can spin the argument, as you can tell. So if I return to your question, Adarsh, what's the prospect of success? That's why I said it depends. It depends on how the argument has been made by the contractor, and in turn it depends on how the employer and its legal team views this. But I would say, as a sort of a concluding comment to your question, even if the change in law clause change in law clause fails, there are other provisions you can try to go under, like I mentioned earlier. So a force majeure provision, for instance, variations provisions, for instance, and that may be the way to peg it if you find yourself stuck in a corner when you're seeking to claim in particular cost entitlements.
Thank you, Vivian.
Yes,
So
thank
I
you,
would
Ms.
like to listen the same thing from Mr. Ramna also from the Indian perspective. So of course we understood, and majorly you might have addressed this issue from the international perspective. So how, Mr. Ramna, it is going to happen in the Indian context?
See, I think I echo the view of Mr. Vijay. What Vijay has said is that the things are in very fluid stage, and you need to actually look at how the arbitrators would look at these claims. The reason I'm saying that this is that the arbitrators are the creators of the contract. The arbitrators have to look into the contractual provisions within the four corners of the contract. So basically, so it is for the arbitrators to consider whether these claims are tenable from the contract perspective. That is one thing that you need to look in. It will be very interesting to see how this jurisprudence would evolve, because what I feel is that we are in a very unique situation, and the way the contract has to be interpreted, we all know that the parties are supposed to act in the best interest of the project, and no one party should be in a very disadvantageous position, whatever is the circumstances. So with that final objective in mind, the arbitrators have to interpret the contract and award the costs or award the claims that have been put up by the contractor. And also, very interestingly, India doesn't have the legislation that the other countries have. So there is no unified way of looking at things, because each of the employer can take a different stand. And I have also seen circumstances where for the same employer, same project, for a different package, because the engineer is different, he has taken a different stand. So there are multiple stands that are taken by the employers. So that is a very uncomfortable situation, because this is going to be a long-term process. This is going to be a very tedious and a contentious process, and we have to wait and see. And as Vijay has rightly said, it depends. It depends on many things.
So, right, sir, right.
Yeah, that's what.
So, fine. Thank you for your giving a Indian perspective, and I believe there is no clear-cut law also, because it is a new thing. So there is no single point of, one point which is everywhere applicable, and there are so many school of thoughts going on related to the COVID-related claim. So it is very difficult to answer in a black and white, as Vijayan also said, and you also said the same thing. So I think both Indian and international perspective, these are difficult to conclude whether it is coming under a change in law or not. So what I understood. So I just asked one more questions to Mr. Nagesh. Nagesh, can you just let us know if a project was already in delay mode when the pandemic started, then how could it be dealt in the extension of time and the cost compensation claims before pandemic and after pandemic?
Hi. Adarsh, yes, this is a very good question. Before I answer this, I just would like to add on that change in law, perspective of this issue, these COVID-related claims, is that I think many of us would be aware that when this pandemic started, FIDIC issued a guideline to tell the industry that how this change in law provision would operate in FIDIC contracts. But of course, the FIDIC contracts are modified in so many different ways and used in particular projects and all that. Of course, the particular conditions that would have modified the standard FIDIC clause. But if you take the standard FIDIC conditions, the change in law, the provision relates to the law, the applicable law. So the definition of applicable law is not only the act of parliament, local authorities' instruction or the directive or an order also constitutes a law of the country. So what FIDIC said is that it could be interpreted that way, that if a local authority issues an instruction to restrain the public movement or the economic activities, then that would be a change in law. So I just wanted to add that there are certain guidelines issued, but of course, as Ramana said, if the FIDIC contract clauses have been modified or different form of contract was used in the project and in Indian context, this may not be widely applicable. But in some contracts where I was personally involved as well, that FIDIC standard forms were used, and then where this change in law provisions were interpreted in a way what Vijayan in his the first talk, he said that this law would mean local authorities order or this even a decree and so on. So now coming to this your question of say if a project is already in a delay mode, how could this the pandemic delays or disruptions could be considered in an extension of time or the delay cost claims. There are ways in which it could be done, I believe, is that see actually this Society of Construction Law Delay and Disruption Protocol talks about both delays and disruptions. But mostly we used to think about the delays, but the disruption analysis is a separate body of analysis itself. Okay. So what SCL protocol has set out guidelines on various methods in which this disruption could be analyzed. Okay. I mean, I will not go into the details of how this analysis and different methods are used and what are the advantages and disadvantages of these methods, because that could be a separate webinar itself. But what I wanted to say is that if one of the the most widely regarded internationally as well is the disruption analysis done by measured mile approach. The measured mile analysis is something which is useful in the COVID situation as well, because as you mentioned, this when a project is in a delay mode, then it goes into the pandemic situation and it further drags the project and delays the project. How it could be factored and how this disruption could be considered into the entire extension of time, entitlements, and attribution of delays and so on. So in my view, the project is already delayed and there is a delayed progress, and a benchmark or a baseline productivity could be established, which is a pre-COVID productivity. Though it is impacted, it will be a pre-COVID productivity. But when it comes to the pandemic situation, the productivity, it will have dropped substantially. Then you will have further impacted, for example, or disrupted productivity during the pandemic, and then that would actually show the loss of productivity. But it is not an easy analysis, but it is doable. in a sense that the benchmarking or the baseline productivity, sampling, the work or trade sampling would be important. And then we should be comparing like with like works. And then that this loss of productivity could be established. So once this loss of productivity could be established, then of course the cost associated with could be worked out. But when it comes to disruption, not all the disruptions lead to delay in completion. So disruption could be localized disruption. The disruption could be to the one part of the work where a particular skilled worker or a technician was not available, or a particular type of equipment has not arrived. Okay, so I mean, disruption could cause delays, but the disruption could be in such a manner that it could cause a critical delay to the project so that the completion is delayed. So a disruption analysis, which could be done separately, and then it has to be fit into the the overall delay analysis of the project to establish and see whether the disruption has caused the critical delays or a disruption was a localized delay. Even if a disruption is a localized delay and the cause of disruption is attributable to the employer under the contract or at law, then the cost, additional cost of the disruption could still be claimable, irrespective of whether it has caused a critical delay to the completion or not. Okay. So I think to answer your question, the thing is that it is possible that the pre-existing delay, when it is still continuing, you are actually able to do a disruption analysis in that impacted situation, and then incorporate those into your extension of time or cost claim.
Thank you, Nagesh. And I understood that disruption analysis is itself, very complex things. And most of the time, this is the hot topic in calculations and claim. So I want to ask one more questions to Mr. Ramna. He represents the India's one of the top tier EPC contracting firm, Tata Projects. So Mr. Ramna, I just want to understand that what we face queries from our client, that employer is saying that if you have not been delayed, then you might have not fallen in during the COVID condition. And contractor wanted to take the advantage of the COVID situation. So how do you handle these things? And I would want to answer from the contractor perspective and the employer perspective both, if you can address both the perspectives.
That's a very interesting question. What I would like to say here is it all depends on the facts and circumstances of the contract. As you rightly put, if the contract has been delayed, and who is responsible for that delay is the most important thing. And that is where the professional services of people like Mr. Nagesh comes in, because they would be establishing who would be responsible for the delay and whether the delay is attributable for the employer or it is attributable for the contractor. And this is going to be a very contentious issue. What is important is that if an employer takes a stand that the delay is attributed to the contractor, and because of the delay attributed to the contractor, the project has been pushed into a scenario where you land in a COVID period, and then it's further delayed. Obviously, it is very difficult for a contractor to defend that matter. But of course, it all depends on the who is responsible for delay, and that is the most. That's a question of fact. That question of fact has to be determined, and the rights and obligations arising out of it would be depending upon the facts of each case.
Mr. Ramna, just I understood it's a complex thing. We do during the delay analysis, we also establish the attributability of the delay, whether it is a contractor's delay or an employer's delay or a concurrent delay. Despite our clients, or especially the contracting firm, wants to understand that suppose because of the employer delay or a contractor delay, but it has fallen into the COVID period, but even contractor or employer was not aware of that the COVID will come. So how it will be slightly different differently treated from the general prolongation claim, or how would you mark the prolongation claim because of the anybody's delay and COVID related force majeure delay? So it is a mixing kind of thing. So our client and especially contractor getting confused on that.
Correct, correct. So ultimately the claim depends upon whether the claim is for a period, original contractual period, or whether it's a claim coming falling under the extension of time claim. So it is basically for you to strategize how you would like to put these claims for the arbitration. And I have touched upon it, and Mr. Vijay has touched upon it earlier. There is no definitive answer to these queries. It is still an evolving process. But if you ask me, and if I have to take a call, and I have to put a claim with regard to a claim that has been postponed, I would like to put these claims along with the normal prolongation claim of the contract.
Right. Thank you, Mr.
Sorry, if I could add to what Ramana has said just now. It is a difficult question to answer because the facts would determine the attributability, right? But when we do the delay analysis in such a situation, see, if the employer is right in saying that if you would have completed the project on time, you would not have been in this situation, and therefore you are not entitled for any further extension or whatever. But in my view, they are not correct, because the contract performance is dependent upon what is happening on day-to-day basis at the project site. It could be that due to some contractors' delays, the project has fallen into the delay mode. But whether it is such an offense that it should not have happened. See, if the contractor has no excuse, the remedy is the liquidated damages under the contract. But if the contract has fallen into the delay mode, but a delay which is an excusable delay happens during that delay period, the contractor will be entitled for extension of time for the quantum equivalent to that of the delay which happened, which is an excusable delay. But the rest of it, the contractor will be liable for liquidated damages, isn't it? So I think the position will be this, that the delay analysis will establish who is responsible for the delays, irrespective of whether it is during the original contract period or during this a COVID situation period, and then it would bring it together to quantify what is the total delay caused by the contractor, what is the total delay caused by the employer, whether there are any concurrent delays and so on, and then what should be the liability of each party. That's my view. I think Vijay would be able to throw some light on this.
Yes. Thank you, Nagesh. And Vijay, can you just give your international perspective also, especially in the Singapore, because most of the Indian arbitration are Singapore-based, SEAC-based arbitration and Singapore-seated arbitration. So we will definitely love to hear about Singapore perspective also.
Thanks for those comments. It's quite interesting because this issue of concurrent delay is a very tricky one to navigate in the context of COVID. When you layer it with a universal problem that's widespread and almost immediately would cause sort of stoppages of work, significant stoppages of work, how do you sort of apportion, sort of blame? And this was actually one of the problems that one of our contractors faced on a major railway project in Asia. I won't go too much into the details of that project, but this issue of concurrent delay sort of arose, and so I just want to sort of unpick this, sort of what Nagesh talked about. If there was already delay on the project, and then COVID came about, sort of made things a lot worse. What's going to happen in terms of liability? So if we go back and sort of do this, in a chronological step. if on one hand, on the project, there was, say, employer culpable delay, right? So the project is already being delayed, and let's say employer culpable delay arises from various scenarios, as you can all imagine. It could be a delay in issuance of design drawings. It could be a delay in the provision of the site. It could be a delay in approving variations or to obtain, say, regulatory permissions. Ordinarily, for employer culpable delay, the contractor would get time and cost, subject to obviously all your notice and substantiation requirements under the contract. So that's where the state of play currently is. Then COVID comes in. So COVID now is a second variable, and everyone will be familiar that COVID is largely a neutral event. If you go under force majeure, which is likely to be the provision you instinctively go under, you get time, but you don't necessarily get cost. So as things stand, the two variables are, one, existing employer delay, for which a contractor is entitled to time and cost. Two, the second variable is sort of like what Nagesh said. Nagesh said, COVID came about, but it is an event for which a contractor is entitled to time, but not necessarily cost. So what happens? An employer may therefore say, all right, in both circumstances in these two variables, you get time. But if there is concurrency in both the delays that are caused, in other words, the employer culpable delay and COVID, which came about, you are then going to be entitled to costs for the same period of concurrency, even though some of the delay was concurrently caused by my failure to, for instance, timelessly issue drawings. So in a way, an employer may mount an argument that whitewashes its cost liability for its own delay in the context of COVID coming about to layer the period of time over which works has been slowly progressing or delayed, etc., etc. And so this is a potential argument that you might face. So, Nagesh's answer to the hypothetical raised by you, Adash, is quite a real one, because employers are likely to deploy that argument to sort of cover up its delays on the project, which for all mega projects would be fairly common. There's a question of attributability. But if it's something that's attributable to both the contractor at the start and when COVID came in, then there can be no question about it, right? The contractor doesn't get cost, right? But if it's an employer culpable delay, I think the complexion may be quite different. And therefore, there may be a need to, I think, carefully and properly consider the kind of arguments that an employer may make or an engineer may make against a contractor's cost claim over the same period of time over which COVID arises. And in fact, when we advised the contractor, we looked at the problem and we said, actually, it's not capable of an immediate answer. I think we need to think about it, and we issued ultimately, I think, a 5 or 6 page advice breaking down the two variables and breaking down how concurrency would operate in the same period of time. So it's not straightforward. I mean, Venkata has mentioned that multiple times, and it is particularly for circumstances like these that you mentioned, Adash and Nagesh. I think both of you are on mute, Nagesh and Adash.
Adarsh, I think you're on mute.
Yeah, sorry. So thank you, Vizen, for your insightful thoughts and giving international perspectives. And it's very clear that there is no clear-cut answers, and of course things are going on. So in that sense, I would like to ask one question from Mr. Nagesh also. So Mr. Nagesh, the cash flow into the project has worsened from the start of the pandemic also, and many small contractor is issuing especially a cash flow issue, and their project has been stalled and their work has been stopped. So what are the support measures and relaxation in terms of progress payments, claim settlement, and a bank guarantee expected to from the employers by the contractors. Because see, what we understood that of course we represent employer also, we represent contractor also, but what we are realizing that contractors are mostly aggrieved party here, because they are losing the work productivity, and contractor is not very rich in cash flow. So that is major concern for the contractor. Can you throw some light on this? Mr. Nagesh, you are on mute.
Sorry, this time it's me. Actually, yes, this is a real problem, because the cash flow is something which is vital for any construction project to progress well and complete. So of course, the contractors will be looking at, whether I would be getting paid for whatever the work I have actually done. Okay, so that is something that, whether the employer as well as the certifiers would be willing to shorten their processing time, say the certification time or the payment time, if it could be shortened, and then the cash can come in, as soon as possible into the bank accounts of the contractors, so that that money could be pumped into the project to progress and complete. Then it came to, of course, when it comes to performance bank guarantees, as I mentioned earlier as well. So in my understanding, Government of India has come up with order to all the these government projects and the entities to say that you reduce your bank guarantees to the extent that the works are actually completed. Okay, you reduce it to even the percentage of this bank guarantee, reduce it to 3%. If it is a 5% or 10%, you reduce it to 3%, basically. So this initiative is there. So it is benefiting some projects actually. But the thing is that the Government of India also is mindful that if there are going to be disputes, or there are indications that there are disputes in the project, then this relaxation, it won't apply. So it happens that unless you don't have a dispute, which you don't contemplate that this dispute would go to arbitration subsequently or in the future, and you would not be given this relaxation. So it is something that the contractors and the employers should look at in a practical perspective, to say that okay, even though at this point in time we can't be really sure whether the matters will be resolved across the table, or subsequently it will go into arbitration. If the employers are willing to support the project and the contractors, they would be able to reduce the performance guarantee. So it is actually, in my view, I think it is purely on a negotiation point of view as well. Then, of course, contractors will be willing to get this, the variations claims assessed as soon as possible, and then the payments made for the variation works as well. So then comes this claim settlements. Wherever the claims are being put forward, then those claims could be, if it could be resolved across the table, or at least with a conciliation effort without going into a full-blown arbitration situation, then the contractor would be something very interested to sit across the table and resolve the situation. So this entire aspects of various actions, both the contractors and the employers would be taking in the best interest of the project, that would actually help with the cash flow to the contractor and early completion of the project. That's what I believe.
Thank you, Nagesh. So I would like to ask Mr. Ramna also the same questions. I actually, Mr. Ramna, who represent Tata Projects, and Tata Projects may be an employer for the small contractor also, and Tata Projects itself a contractor for the employer also, especially for the big PSU companies. So Mr. Ramna, just I want to understand, is there a different yardstick in terms of compensation of the cash flow and all? And how are you satisfied in case, without naming the name of the employer, how the employer employer are compensating to address the cash flow issue of the contractor. So what is your point of view, Mr. Raman?
Yeah, I think Nagesh has rightly touched upon it. One of the major concessions that came from the employers is that reduction of bank guarantee, performance bank guarantees. But that comes with a caveat. That is, if there is any dispute or if which is underway, or if there is any notice of dispute was given, or if an arbitration notice has been given, and that reduction is not possible. So that is a major constraint in any construction contract, and especially in certain circumstances. There will always be dispute between the contractors and the employer. So that is a major constraint. So it's not that across the board this reduction has happened. And another important thing again, Mr. Nagesh has touched upon, is to try to get your variations set quite quickly, get your bills cleared promptly, and maybe there can be certain changes in the contractual terms with regard to the queues and other issues. And also one important relief that the contractors have got is with regard to the extension of time. Certain employers are given extension of time from 3 months to 6 months period, without requirement of a delay analysis. So there are certain reliefs that have come. And some employers have settled certain labor costs that the contractors have incurred during the COVID time for maintaining labor camps or for maintenance and payment of wages during the COVID lockdown, initial COVID lockdown period. So some employers have acted proactively and trying to resolve this, but that's not enough. I think ultimately most of the claims that the contractors have claimed will definitely go into a very contentious zone, and they have to be adjudicated by an arbitral tribunal. Again, I'm saying this at the cost of repetition, whether the arbitral tribunal has to interpret uh, within the four corners of the contract. Again, whether the force majeure has been, includes this event. Again, all this will be a very highly contentious dispute. We have to see how this evolves.
Right, Mr. Kadamna. And in fact, in morning session, Justice Sikri was emphasizing on the same thing, because COVID-related is such a dispute, and COVID-related claims is such a hot topic. So he was emphasizing on the mediation part also. So it should not go into the arbitration, because even employer is not on a faulty side. Of course, contractor is claiming that whatever the employer has compensated 180 days or 6 months with extension of time, and employer has compensated some idling cost as well. But contractor feels it is a peanuts for them. So they should sit across the table, and it is just advice from the industry veterans that without getting into the arbitration, they should sit together and find out some intermediate way instead of getting into the arbitration, because there is no per se perfect law or some clear-cut law per se. So that is my point of view also. And fine. So Vijayan, I just want to ask one more questions. You have handled many COVID-related disputes. So how many of them, in fact, progress to the arbitration? And is there any specific arbitration strategy for the COVID disputes?
Thanks, Adarsh. That's a practical question, because it goes right to the heart of a contractor's concerns. In fairness, I think there has been quite a lot of hot air being blown around by a lot of parties when it's COVID. Both contractors and employers, and even the consultants on a project. So basically all stakeholders. And it's quite an interesting question, because a lot of the COVID dispute work currently, I think, revolves around, I would say broadly, three things. One, internal advisors to the client's management, which, companies like Tata would obviously need to make an informed decision. Two is the preparation of claim documents, and that takes time. You need to sit down together with the project team, the consultants, with the legal team to put together a persuasive analysis that is credible, that can withstand scrutiny. And the third, I think, is just the third kind of work involves around plainly posturing and negotiations, isn't it? To talk about how much you should be getting at the end of the day. So, in short answer to your question, I think most of the COVID-related disputes may not have escalated to arbitration yet. I know one of my colleagues in the Singapore office is currently embroiled in arbitration over, I think, various power plants because of COVID-related claims, but that might be because the matter had escalated quite quickly. Because if you think about it, COVID was in 2020. It usually takes some time for the dispute to sort of brew, and then parties decide that there is no longer any viable hope of settlement. So I would say, not many yet at this juncture, but I wouldn't be surprised to see it emerge in the next half a year or year. The second part of your question relates to sort of arbitration strategies for COVID-related claims. And truth is, it wouldn't be any different from any arbitration strategy of other type of claims, so putting aside COVID. But I would think that the first and probably the most important thing is not a legal strategy. It might be a more human strategy, and that involves perhaps the selection of your tribunal. I say that because a COVID-related dispute would inevitably boil down to an interpretation of the contract, the provisions which one party says entitles or disentitles you to time and cost. And so therefore you may want to consider, depending on which side of the fence you're sitting on, who your tribunal is. Is your tribunal member someone who is likely to be a strict literalist, textualist in his jurisprudential philosophy? Is he or she, pardon my gender mispronunciation, is he or she likely to look at the contract on its plain wording and say that's your entitlement and no further? So if you're a contractor and employer and you know the contract you're stuck with, it's important to know where your weakness lies and then decide, perhaps thinking ahead, who your tribunal member may be, depending on his judicial philosophy. And for instance, I give an example. Because we have multiple offices across the world and we interact with various arbitrators, generally we know how they may think because we may have come across them as counsel, as tribunal member. And so generally we may know someone's judicial philosophy. And while it's not a foolproof answer and it's not some recipe that you can get for a solution, it gives you some insight into how the arguments may pan out. Or, for instance, is your tribunal member someone who may be more sympathetic to the justices of the matter? Because arguably, contractors are the most badly hit. So is your tribunal member someone perhaps who would be more sympathetic to the cause of a contractor? Things like that, strategic considerations to think about in a COVID-related dispute, particularly because it boils down to interpretation of contractual provisions. I mean, there are obviously other various strategies, you may want to think about in arbitration, but they are not different from the typical ones. For instance, should you bifurcate your hearing to save time and cost? Do you carefully interrogate the quantum claimed? Because one of the points raised earlier was in subcontractors' costs. So a contractor may very well pass upstream to the employer its own subcontractors' costs as part of its claim. Have these amounts been properly interrogated? Are you entitled to pass them up? Things like that in terms of approach on the papers that have been prepared for the arbitration. These are important to think about as well. So I would say, in short, arbitration strategies, perhaps tribunal members and composition is quite key, but the rest of it, I don't see too much difference in substance between how you would run a typical international construction arbitration versus a COVID construction arbitration.
Thank you, Vivian. Thank you for your insightful thoughts. So I would like to just put one very important and $1 million questions which need to be asked at the beginning of the session itself. And I would like to put this questions to Mr. Ranna also. And later on, I will come to you, Vivian, also from the international perspective. That how the COVID is considered as a force majeure, because it is a monotonous questions. It has been keep asking and it has been keep asking hosting every webinar from the day one when COVID has erupted. But definitely we would like to listen from Mr. Ramna because we could not get an opportunity to hear from him, and definitely Vijan also how the COVID is considered as a force majeure or not, if the word pandemic is not in the contract, or if it is there, or what fact is something unforeseen error is not in the contract. So how it should be treated. So over to you, Mr. Ramna.
See, I think you asked a very pertinent question. I think Mr. Gaurav Banerjee in the first session has also answered this query. Basically, under Indian law, force majeure clause cannot be implied under Indian law. It must be expressly provided for under the contracts. So that is the most important element. So of course, there are ways you interpret to bring in a wider interpretation to this clause. That is one thing. And the most important thing from the Indian law perspective is on 19th Feb 2020, the Ministry of Finance has come up with a office order, and they have clearly said that it will be covered under the force majeure clause. So that is a very big relief for the Indians, and it sets to rest this debate if COVID is not mentioned under the head of force majeure or a pandemic is not mentioned under the head of force majeure, will it not be a force majeure event? You know, that I think that argument is set to rest now. I think that there are 2-3 reasons for that. You know, one is that this is not a case of a tempest or a localized flood or a localized storm that we are referring to. We are referring to a calamity which is across the globe, and somebody to say that this is not an act of God or this is not a force majeure event just because the word pandemic is not appearing under the force majeure clause will be a far-stretched argument. And I think there is no question whether this is a force majeure event or not. The question is more on under what heads the contractors will be entitled for costs, and under what heads you will be entitled for time. So that is the question that is being, which is more relevant today, rather than whether the COVID is a force majeure event or not.
Right. So thanks, Mr. Ramna, to give a light on this. And Vijan, just ask the same questions to you also. You can just touch base the international perspective of the same questions. So would like to hear from you, Mr. Vijan.
I mean, I would say, like, again, my answer to the earlier question you asked, it really depends. But that said, I'm leaning towards Venkata's answer as well, that it's likely to be force majeure. And I say that, don't quote me as though it's legal advice. And that's because, you know, if you think about it legally, in a typical force majeure clause, of course, subject to the express wording of your particular clause, there are generally 4 elements in law. First is it must be an occurrence of a specified event in your clause, right? So when Venkata talked about, you know, does the word pandemic appear, or perhaps is it called endemic? You know, is it called something like that, epidemic? You know, that really depends. The second thing is the fact that it must impact a party's performance of its contractual obligations, right? So that's the general second broad legal analysis that's undertaken. And there could be some questions around what impact means. Does impact means you are hindered? Does impact means you are prevented? Or does impact mean you are disrupted, delayed, affected? And these are different gradations of the word which a contractor may need to establish to demonstrate that COVID falls within its specific event. So these are legal arguments. I mean, the third and fourth general legal requirements are whether or not it's due to circumstances outside your control, which I would think the answer is yes, it's COVID. And the fourth sort of requirement is that you could not have taken reasonable steps to prevent or mitigate it. And I would think for COVID, that's probably right. So the contention may very well lie on the first 2 legal criteria. And while, you know, there could be a variety of innovative, creative arguments, I would think that if you meet a tribunal, any international arbitrator, and you make such arguments and you say, well, actually, you know, it's pandemic, it's not epidemic, you know, it's impact, it's delay, it's not hindered, it's prevented. You know, an international arbitrator may think, actually, come on, surely he would fall under that. Let's not split hairs over semantics. And the question may then be, as Venkata said, putting aside the force majeure clause, which perhaps only entitles you to time, what are your arguments on cost? Are you going to make an argument for that? Because that's truly the contentious one. That's going to plague a lot of arbitrations. So perhaps this question, may wish to be framed a bit differently. Maybe not is it a force majeure clause, but does COVID entitle you to costs? And let the wild Hunger Games begin on whether one party will succeed on this argument.
Thanks, Vijay. Just one follow-up question. You have addressed, appeared in so many international arbitration also, and you are aware of the Indian dispute as well. Is there some international guideline which is a sacrosanct, because COVID is a international phenomenon. It's not a country-wise different. So, of course, I can understand there might be some local laws and orders passed by the Supreme Court or some government of India or something like that. Just Mr. Ramna has mentioned a few minutes back. So is there some standard international guideline which has to be followed across country, and is there something like that? I'm just not aware of that and just want to understand from you.
And I think it's very unlikely, because a lot of the jurisprudence is specific to your country. And that usually, perhaps provides financial relief to local contractors. Well, not just local contractors, but contractors who may have set up base in your particular country. So for instance, Singapore, there was a COVID Act which provided various financial relief to contractors in Singapore, and that extends beyond financial relief. It also extends to, for instance, the inability of an employer to call on a bond for a specific period of time, because they know that that's one of the common recourses that's been made. But if the question is there a trend across countries? I wouldn't think so. It really depends on your individual jurisdiction. And therefore, in international arbitrations, it depends on the governing law of your country. And the governing law is important for the interpretation of the contractual provision, which gives you that entitlement. I mean, the common sort of comparison is, for instance, in typical FIDIC contracts, you have notice requirements, 28 days, in the first notice under FIDIC, etc. But I know, given discussions with various Indian colleagues, that may be somewhat different, because there are various statutes in India which doesn't require the time provisions to be kept to. I think it's section 20 something of your Indian legislation. And so therefore there might be a disparity in that, in treatment of that. Whereas, for other international arbitrations, perhaps there wouldn't be. So if I were to just end off that point, I would just simply say you might have to look at the governing law, go to a legal team which is qualified in a particular jurisdiction, and then seek advice on whether or not there's a particular way to get out the conundrum you're in. I wouldn't think there's sort of a universal philosophy as to how to treat COVID and its claims.
Great. Thanks, Vijay. So this COVID is such a hot topic. So even entire day would be less for the discussion. And so despite having a lot of discussion in different webinar on the COVID topic, there's no dearth of questions, and still questions are keep flowing from various places, contractor, employers. What should be the way forward? So I would like to ask Mr. Ramna to conclude this. What the way forward? It in evolving. There is not judicial authority as of now, as you said, and each of the claims has to be dealt within the four corners of the contract and to go through dispute resolution process. It is a time to drawn process that still depends on the state of the project, whether it is the original contractual period and extended periods, whether these claims are persuaded along with the EOT claims or other arbitration that is being persuaded. So what is your concluding remarks, Mr. Ramna, on this?
Well, I think it is evolving. There are various variants. Not only COVID variants, in arguments, variants in approach to the problem. I think it's all boils down to prudence, and it all boils down to, as Vijay has rightly put it, the arbitral tribunals who ultimately want to do justice, and none of one of the parties should be in a great disadvantageous situation. I think that should be the approach. As you have rightly said, it is still fluid, it is still evolving. Ultimately, one of the party has to bear the cost. There's no question about it. Whether it is employer who has to bear the cost or the entire cost has to be borne by the contractor is something which has to be decided. I think the approach should be more a judicious and a balanced approach to this problem. That's how I would look at it. And one more important thing I would like to place here is that while I agree with Vision when he says it is the arbitrators who are adjudicating this dispute, it all depends upon how they adjudicate, what is their approach, whether they are judicial or whether they are equity prone. I would put it this way. If there is no unified law or if there is no unified guidance on this, there will be multiplicity of views. There will be multiplicity of awards, and that would lead to a lot of confusion. I think a good sense should prevail, and there would be some kind of a uniform guidance or uniform guidelines which can determine these disputes.
Thank you, Mr. Ramna. So, Mr. Nagesh, what is your concluding remarks on the disruption claims and loss of productivity? Just in 1 or 2 lines, if you can conclude this.
Others, thanks for asking me this. Vijay and Mr. Ramna has quite nicely summarized the issues and where we stand as of now. Of course, the claims of contractors, it had to be dealt with, as Mr. Ramna said, in a uniform manner. So either it is in front of an arbitrator, or the employer is looking at it, or an engineer is looking at it. They should have some unified guidance on this. But that unified guidance can come from an act of parliament. So, for example, Vijayan has touched upon it, that in Singapore there is a act of parliament, COVID-19 Temporary Measures Act, which specifically deals with reliefs available and applicable to various businesses, including construction stakeholders. So being this the Confederation of Indian Industry Forum, I would propose that the industry level, or even in a multiple industry level, initiative could be taken to actually come up with a guideline for various businesses, including construction industry as well, to tell that what is acceptable, what is not acceptable, and how these time and cost have to be dealt with among the parties involved. Either any one of the parties are responsible, or it should be a shared responsibility of the parties, and so on. So I believe unless there is the higher level, national level initiative to come up with a guideline or even an act of parliament, I think the unified approach would be very difficult to achieve. So I would take this opportunity to put forward this proposal that Confederation of Indian Industry could take an initiative with all the industry key players, with the help of eminent lawyers and justices. We listened to this morning that that such an approach could be framed and developed, and then it could be used as well. That's my remark.
So Thank you, Mr. Nagesh, and it was really a very insightful discussion and mesmerizing talks by Mr. Ramna, Mr. Vijayan, and you. And despite we were unfortunate that Dr. Vanna Bhatt could not join due to her personal exigency and last minute dropout from Mr. Montek Mayal also. But this discussion went into a very effective manner. And now we would like to open this Q&A sessions. And Vandana, if you can just pick up a few questions from the chat box, it would be much appreciated if you can take up 2-3 questions from the audience. Vandana, are you there?
Yes, Adarsh, I don't think I have access to the chat. So
okay, let me see. Just a minute, I'm also unable to see some chat box. So someone from CII IT team can give access to, that we can have access of the chat box so that we can pick up a few questions from the audience. Hello, Vishwanath, are you there or Ritim?
No question, sir.
Achha, no question in the chat box.
I believe, I think we have covered most of the topics, so the audience don't have any more questions.
That's
no
great.
problem. Maybe the one reason that what Vandana said, and the second reason is we are apologizing. We are really behind the schedule, and it was half an hour delay from the beginning of the first session itself.
I understand.
And this session was supposed to be completed by 2 o'clock, and now it is almost 2:50. So we are running around 40-50 minutes behind the schedule. So some of the participants might have logged out also at the very last moment. But despite it was actually we have forwarded the YouTube link also. So many people have started watching on the YouTube directly instead of joining this webinar through the Webex portal. So YouTube is always convenient. Just to put a click on the mobile and you start listening all these things. So, so that might be the one of the reasons that participants have not asked a couple of questions. And I have got the feedback that many people are watching this entire sessions live on YouTube because these sessions are live on YouTube as well. Yes, Vandana.
Others, there is one question which has come up.
Yes.
If you would like, I would take it up or.
Yeah, sure. We have a time for another 5 minutes. We can. We have actually requested CII to extend till 3 p.m. So we have a 5 minutes to conclude this.
Okay, so we have one question. Government of India has taken some steps towards relief to contractors in terms of 6 months EOT and reduction of wages. But these actions are not sufficient to take care of the damage to the contractors. Is Government of India going to take further relief measures to help the contractors? So, I request, I think, Mr. Venkat to handle this because it's related to Government of India.
Mr. Ramna, are you there?
I think he lost connection.
So I think, yeah. He doesn't seem to be there.
So, no problem. So,
I think that
yes.
Participants, the questions could be emailed to the if it is to the specific speakers, it could be emailed.
Correct.
And then we could be happy to answer the queries.
No. Excellent idea, Nagesh. And we will request participant to just put there all the questions, and we will circulate this all the answers post event also because of the paucity of time, many questions we could not take it, and which was a very relevant questions and pertinent questions also. So as I said that many participants could not join because of the technical complexity to joining over the WebEx and all. So some people have faced these issues as well. So they have joined over the video, YouTube live. So going for your suggestion is most welcome, Nagesh. We can take up all the questions and then we can give the answers to all the participants.
I also noticed that there are questions posted on YouTube comments as well. So that
okay.
collected and it would be addressed.
Yes, yes, yes. Most welcome suggestions. Suggestions most welcome. So I think Mr. Ramna is back or okay. Is it? No, we are unable to see him. Fine. So we can conclude this sessions and of course, Riddhim, are you there? From CI, Mr. Riddhim, are you there? No problem. So I think it is quite late and it is a lunch time also. In Indian time it's a lunch time and most of the people have dropped the session, say I mean just right a few minutes back. So we would like to conclude this sessions and I would like to thank you Mr. Vijayan, Mr. Ramna and Mr. Nagesh to give their views on such a I mean contentious issues and hot topics which is getting most of the questions from the participants. And apart from the other sessions topics, which is a slightly monotonous, I would say, but COVID is definitely evolving issues, and every questions are almost a new kind of things. So this is a really very good sessions, Mr. Nagesh, Vijay and Mr. Ramna. Thank you all of you. And by this,
Thank you so much, Adarsh,
this
for
okay.
thank you so much for putting up
Thank
this
you, thank you all of
wonderful
them.
event.
Thanks.
Yeah, thank you. Bye bye.
Thanks a lot. Bye bye. Bye. Thanks. See you in next session next week.
Bye.
Thank you.
Bye, Vijayan.
Bye. See everyone.
Bye. See everyone. Thanks.